ಮೇಡಮ್ ಒಂದ್ಸಲ ರಿಫ್ರೆಶ್ ಮಾಡಿ. ಅದೊಂದು ಇನ್ನೊಂದು
ಇದಾ
ಯಾಕೋ ಅಂತ ಕಾಣಿಸ್ರಿ ಇಲ್ಲೇ ಇರಬೇಕು ಜೇಕಬ್ ಕಾಣಿಸ್ರಿ ಜೇಕಬ್ ಕರೆ
Chamber in the slide.
Time-bound direction is issued for them to come back and report. Matter is not to exist.
Contempt matter. You have to move it before the chief. Contempt matter cannot be moved before us. Before the senior judge. In which one? This was Just leave it here, we'll see what it is. Krishna does.
Otherwise, number 29 and 30.
For posting.
Otherwise, page number 6, serial number 29 and 30.
Serial number 29, my lord.
Yes.
I request for a week's accommodation. I have sought for a report from the BDA. They are preparing it, and I have informed the other side also.
You are informed, Mr. Nagusna?
Yes,
What about Mr. Karthikeyan? He also has to file his objections, is it?
yes.
Objections are filed. 2015 matter, Mr. Right, okay.
Yes, my lord. One report, my lord, I have asked them to send. They are
Uh-huh.
preparing the report within 2 days. They'll give 1 week's time, your lordship may grant.
29. Mentioned at 10:30, Shri Praveen Kumar Raikote, when it comes to response number 2 and 3. Seeks for and is granted 2 days time to file an report. They said report to be filed on a report 24/6/2022 after serving a copy thereof on the other.
28.
24, 2 days and 30 days, Mr. Raikote.
ಅಲ್ಲ ಅವರು ಪ್ರಿಪೇರ್ ಮಾಡ್ತಾರೆ, ನನಗೆ ಬಂದು ನಾನು ಕೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ.
ನಿಮ್ಗೆ ಅದಕ್ಕೆ ಇನ್ನೊಂದು 2 ದಿನ ಅಷ್ಟೇ. You file ಮಾಡಿ 28 will list it. You file it on 24. So everybody can go through it.
Yes.
You filed on or before 24, relist on 28/6/2022. Considering that the matter is of the year 2015, no further adjournment would be granted.
Please.
Page number 7, serial number 31 to 37.
Yes.
Serial number 32, I appear for the
Who are you
petitioner.
appearing for, Mr. Shivram? Your name is not shown anywhere. Connected matter P4 to P6.
Serial number 32, I appear for the petitioner, my lord. I oppose the
Yes,
mentioning,
Mr.
my
Krishna.
I oppose the mentioning, my lord. There's so much
Oppose.
urgency.
Rejected.
Great.
Opposed and rejected. You're keeping very well. Ravi.
Great.
Page number 8, serial number 38 and 39. Page number 9, serial number 42.
Yes. You're appearing for Mr. Krishna. Petitioner. Has the objections been filed? 41, learned counsel mentioned 10:30, learned counsel for the petition seeks for and is granted a week's time. Released on 28/6.
Page number 10, serial number 43 to 50.
46, Mr. Bhatt.
46, I appear for the respondent, my lord.
Why do you want adjournment, Mr. Bhatt? You have filed your objection, Mr. Unnikrishnan?
I have not filed, but my lord, the prayer sought for cannot be granted, is my submission.
So you would argue the matter. No need
Yes,
to
yes.
file
What he says, my lord, is that the property needs to be acquired.
He needs a week's time, so we'll give him a week's time.
Very well.
Just a moment. Shri Unnikrishnan has entered appearance for respondent number 3. He accepts notice for respondent number 2 also. Registry is directed to print his name as such. Since Mr. Unnikrishnan has entered appearance, the registry is directed to read the name of Shri K. Krishna as appearing for respondent number 2 and 3, and Mr. Bipin Hegde as that appearing for respondent number 3. Shri Shankar Narayan Bhatt, learned counsel seeks for and is granted a week's time. Week's time or 2 weeks time? 2 weeks time. Released on 5/7. Submission of Shri Unnikrishnan that there will be no requirement to file any statement or objection is placed on record. Yes. Now, who is appearing for the respondent? Mr. Ashwin Chikmat. Since Ashwin Chikmat has entered appearance, registry is direct to read the name of Shri Gopal Bilalmane as that appearing for the respondent. He submits that statement of objection will be filed during the course of the day, has been filed in the morning today, and a copy served on the counsel for the petitioner. Released on 28/6. Yes. You are appearing for? Have you informed the petitioner? Have you filed your objections? Have you filed your objections? Akidar objection. 45. Mentioned at 10:30, learned counsel for respond number 1 and 2 seeks for 2 weeks' time to file a statement of objections. Objections, if any, to be filed on or before 18, before 1/7/2022, released on 5/7/2022. Yes. Why? Have we informed the counsel for respond? Even if it is a government advocate and media advocate, inform advocate. 50. Mentioned at 10:30, learned counsel for the petitioner seeks and is granted a week's accommodation on account of personal inconvenience. Released on 28/6.
Page number 11, serial number 51-58.
Yes. 51. Learned counsel for the petitioner has filed a memo dated memo dated today's date. It has been signed by the counsel for the petitioner, stating that during the pendency of the petitioner, the respondents have considered the representation of the petitioner, and as such, the petitioner does not wish to prosecute the above petition. The said memo on the submission of Sri Nimesvenu. So and so is accepted. The petition is dismissed as withdrawn. Date.
Serial number 58, Your Lordship.
Just a moment. Have you informed the counsel for 56? Learned counsel for respond number 2, 3, 5 to 7 seeks for and is granted a week's accommodation on the ground of personal inconvenience. 2 weeks time. Released on 5/7. Have you filed your objections? Mr. Krishna, you have filed your objections. So pleadings are complete. In the meanwhile, counsel for the petitioner is permitted to file his rejoinder.
Page number 12,
Serial number 58, Your Lordship.
Yes.
Serial number. I appear for the petitioner. Senior is not keeping well. I pray for 2 weeks' time, Your Lordship. Statement of objection is also needs to be filed.
Yaugal, Mr. Krishna, you have filed. Mr. Puttegowda, who is to file? Mr. Krishna says he has filed his objections.
And government advocate has not filed it.
You want to file your objections, Mr. Krishna? And you want to file? ಇವರು ಯಾವುದೆಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಬೇಕಾ? ಪುಟ್ಟೇಗೌಡರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬೇಕಾಗಿಲ್ವಾ? 58 mentioned at 10:30, learned counsel for the petitioner seeks for a short accommodation. Sri K. Krishna, learned counsel for the respondent number 3, submit that he has already filed his objections. Objections of other respondents, if any, to be filed on or before 1/7/2022, released on 5/7/2022.
Serial number 25, appear for respondent number 2.
ಈ ಪೇಜ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ? ಈ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆಯಾ? 11 ಅಲ್ಲಿ ಇದೆಯಾ? ಸರಿ ರೀ. Yes. 61 ನೀವು ಯಾರಿಗೆ? Has the objection been filed by respondent? Yes, sir. It's been filed. Why do you want to have judgment? ಇಲ್ಲ ಇದೀರಾ? Other matters is not a personal inconvenience. High court ಬಿಟ್ಬಿಟ್ಟು lower court ಹೋಗ್ತೀನಿ. ಏನ್ counseling submission ಮಾಡಿ. You can't make this kind of submission. Should we record that submission? ಮಾಡೋಗಿ ಯೋಚನೆ ಮಾಡಿ ನೀವು ಹೇಳ್ಬೇಕು. 61 pleadings are complete. Learned counsel for the petitioner seeks for and is granted 1 week time finally. We list on 28/6.
63. Technical is pending. 3.
What is the issue?
Alternative side.
ಅದಿರ್ಬೋದು ಇದಕ್ಕೆ how does that matter? ಹಾಕಿ ಅದ್ ಕೇಳಿ ರಿಟ್ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಆ ಮ್ಯಾಟರ್ ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಕಾಮನ್ ಹೆಂಗಾಗುತ್ತೆ ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಇಸ್ ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಇಸ್ ಇಂಡಿವಿಜುವಲ್ ಕನ್ಸಿಡರೇಷನ್ Mr. Ramakrishna, alternative site is individual consideration, not a batch consideration. ಇರ್ಲಿ 1000 ಇರ್ಲಿ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಇದ್ರದ್ದು ಹೇಳಿ ನೀವು ಅಷ್ಟೇ. Already dated matter. So we'll impose cost. ನೀವು ಇಂಟಿಮೇಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಕಾಸ್ಟ್ ವೇವ್ ಆಗಲ್ಲ. We'll impose cost. The matter was listed. The counsel for the respondent had been permitted to file his objections. Objections have still not been filed. Today, also Sri Ramakrishna, the counsel for the respondent, seeks for another accommodation to file his objection. No such indulgence is required to be extended. However, in the interest of justice, 1 week's time is granted to file the objection, subject to the condition of payment of cost of 1,000 to be paid to BDA or ಕೊಡ್ಲಿ ಅವ್ರು ಕೊಟ್ರೇನೆ ಅವ್ರು ನಿಮ್ಗೆ ಬೇಕಾಗ್ತದೆ. Cost to be remitted to the advocate's library fund within a period of 1 week from today. Statement of objections, if any, to be filed on or before 30/6/2022, relist on 5/7. Yes.
Appearing for respondent number 3 in this case, my lord.
Yes, madam.
My lord, I've been served the copy of the survey report today morning. I need to go through that and file my objections to that. Serial number 69, my lord.
You have filed your objection. 69. Learned counsel for the petitioner seeks for a short accommodation. Learned counsel for the respondent number 3 submit that she has received the survey report today morning. She also requires survey report today morning, and she also requires a week's time to file her objections. Objections, if any, to be filed on or before 30/6/2022, relist on 5/7. Or 1 week ಬೇಕು ಎಲ್ಲ ಅದು. Serial number? ಏನಕ್ಕೆ? You're a proxy counsel. You filed your objection. Learned counsel for the petitioner. On behalf of the learned counsel for the petitioner, a week's time is sought for on the ground that the arguing counsel is unwell. Learned counsel for the respondent submit that he does not wish to file any objections but would address arguments. We list on 5/7.
Page number 30, serial number 70 to 79.
77.
74.
Mr. Sachin, who is appearing? 77, who is appearing now? Vaibhav, Sachin, Karthikeyan, new resident. You are appearing. Shri B.S. Sachin has entered appearance for respondent number 2. He accepts notice for respondent number 1 also. Registry is directed to print his name as such. Since Shri B.S. Sachin has entered appearance, registry is directed to delete the name of Shri R. Vaibhav and B.S. Karthikeyan as that appearing for respondent number 1 and 2. Learned counsel for the petitioner seeks for and is granted a week's time. Objections ಹಾಕಿದ್ದೀರಾ? ಹಾಕ್ಬೇಕಾ ಹಾಕಿದ್ದೀರಾ? ಕೇಳಿ ಅಲ್ಲಿಂದ ಹೇಳ್ತಾರೆ. Seeks for a short accommodation. Shri B.S. Sachin also seeks for 2 weeks time to file a statement of objection. Objections if any to be filed on or before 1/7/2022, released on 5/7.
74, my lord.
Yes.
I appear for the petitioner. In this, I was told that petitioner is no more. So I need to bring the legal aid on record.
74. So, Mr.
74.
Lakshmi, you are appearing in this. The Lakshmi Rao has entered appearance for respondent number 123. Registry direct delete the name of Shri Ajay Kumar as that appearing for the respondents. Shri Venkatesh Murthy, learned counsel for the petitioner, submits that the sole petitioner, Mr. Murthy.
Yes, my lord.
The sole petitioner is expired. He seeks for 2 weeks time to file necessary applications.
Please.
Released on 5/7.
Much more.
ಆಗತ್ತೆ ಅಷ್ಟೊಳಗೆ?
ಆಗತ್ತೆ sir. ಆಗತ್ತೆ. Much more.
Page number 14, serial number 80-91.
You filed the objection, Mr. Vachan? No, dated matter. Was date given for you to file objection? You're not given date for that. Okay, 90. Learned counsel for the petitioner submits that the sole petitioner is expired. He seeks for 2 weeks time to file necessary application to bring the legal authority on record. Shri B. Vachan seeks for and is granted 2 weeks time to file a statement of objection. Objections if any to be filed on or before 8/7/2022, released on 12/7/2022.
My lord, serial number 88 and 89, my lord.
88 and 89.
Yes, my lord. And for the respondent, I have not filed my objections, my lord. I have sought for instructions.
Have you informed the counsel for the petitioners?
I have not. I will inform him, my lord. I will inform.
Yes. Any objections? ಅದಕ್ಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. 88. Shri Vinny Krishnan, learned counsel for respondent number 1 and 2 seeks for and is granted 2 weeks time to file a statement of objection. Objections if any to be filed on or before 8/7, released on 12/7.
89 also.
Order earlier granted is extended till next date appearing. 89. Shri Vinny Krishnan has entered appearance for respondent number 1 and 2. Okay. Shri Vinny Krishnan, ಯಾರು 89 ಅಲ್ಲಿ petitioner ಯಾರು?
Rahul.
Inform?
ನಾನು ಮಾಡ್ತೀನಿ ಸುಮ್ಮನೆ.
ಮಾಡಿ ಬೇಡ.
ಈಗಲೇ ಮಾಡ್ತೀನಿ. I will inform.
ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ.
ಆಯ್ತು.
86. ಇವೆರಡೇನ ಇರೋದು, ಇನ್ನ ಬ್ಯಾಚ್ ಇದೆ. ನಂಬರ್ ಕೊಡಿ. 84 ಅಲ್ಲಿ ಮಿಸ್ಟರ್ ಅಜಯ್ ಕುಮಾರ್ ಇಸ್ ಅಪಿಯರಿಂಗ್. 84. Counsel for respondent submit that the above matter relates to the levy of betterment charges, which is connected to WP number 11693 of 2020, comma. He seeks for 2 weeks time. 3 weeks time. ನೀವೇನ್ ಕೇಳ್ತೀರೋ ಅಷ್ಟು ಕೊಡ್ತೀವಿ, ಆಮೇಲೆ ಕೇಳಬೇಡಿ. 3 weeks time to file a statement of objection and get ready to address his arguments. Objection statement to be filed on or before 8/7/2022, released on 12/7/2022. 86 same order, connect to 9885 of 2020.
Page number 15, serial number 92-99.
93, my lords.
Yes.
My lords, 2 weeks time may be granted. My lords, I have informed the other side as well, my lords, this morning. My lords, I need to file my statement of objections.
Who is appearing for the petitioner? Mr. Mallikarjun is appearing.
I have informed my lords.
Mallikarjun NK has entered appearance. Who have you informed, Mr. Patel?
Ma'am, my lords, I have informed Mr. Venkatesha, my lords. Through Venkatesha, my lords, I have informed Mallikarjun, my lords. Because he has filed NOC, my lords.
has entered appearance for the petitioner, registry that delete the name of Sri Venkatesha H and H. Venkatesha Doderi as that appearing for the petitioner. Sri Suraj Patil, learned counsel for the respond number 2 and 3 seeks for and is granted 2 weeks time finally to file a statement of objection. Objections, if any, to be filed on or before 1/7/2022, released on 5/7/2022. Sri N.R. Girisha has entered appearance for respond number 2. Registry is direct delete the name of Sri K.N. Krishna as that appearance for respond number 2. Sri N.R. Girisha seeks and is granted 2 weeks time finally to file a statement of objection. Objections, if any, to be filed on or before 1/7, released on 5/7.
Case number 16, serial number 100 to 104.
Sri Murugesh Charity has entered appearance for respond number 1 and 2. Hence, registry is direct delete the name of Sri B. Vachan as that appearance for respond number 1 and 2. Sri Charity seeks and is granted 2 weeks time finally to file a statement of objection to be filed on or before 1/6/17, released on 5/7. Interim order earlier granted is extended till next day.
On humble submission, my lord.
Yes,
Your
ma'am.
lordship, in serial
Serial number
27, your lordship, the matter was in fact listed, office was directed to list it on 27th as the parties were before the mediation center, whereas the matter has come up today, your lordship. The matter in the trial court is in Lok Adalat on Saturday. So kindly the matter may be taken up next week.
Any progress made? Progress made. 27.
Any date after 28th or
today, released on 30th. 30th.
much obliged, madam. Interim order may kindly be
Earlier granted is extended till next day.
My lord,
With the what is kind
serial number
permission.
25. My lord, serial number 25 appear for
25 not eligible for mentioning. Wait, please. Only B group and final year. 68. Objections ಹಾಕಿದಾರಾ? Charity 68 mentioned at 10:30. Learned counsel for the petitioner seeks for a short accommodation. Learned counsel for the respondent also seeks for 2 weeks time to file a statement of objection. Objections, if any, to be filed on or before 1/7, released on 5/7. ನೀವು ಯಾರಿಗೆ objections ಹಾಕಿದಾರಾ? Objections ಹಾಕಿದ್ರ Mr. Charity 71 and 72. Learned counsel for the mentioned 10:30. Learned counsel for the petitioner seeks for a short accommodation. Learned counsel for the respondent submit that the statement of objection be filed in 2 days time. Released on 28/6. 72. Same order.
Order serial number 1.
ಮೂವ್ ಯಾಕೆ ಮಾಡಿದ್ರಿ? ನೀವು ಇಷ್ಟೊಂದು ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? Counsel for the petitioner seeks for and is granted 2 weeks time to comply with office objection. Released on 4/7.
Next matter serial number 2.
Instructions here. Ready na? We have directed to take notice way back, Mr. Vachan. This is on 15/2/2022, you have been directed to take notice. That will take 4 months. Second or third round, 4 months back. We find this problem only with BDA. ನಿಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬರ್ತಾ ಇಲ್ವಾ, ಏನಾಗ್ತಾ ಇದೆ? You are getting embarrassed, but is it because you are not getting instruction? What is the problem? ಒಂದು ನಿಮಿಷ ಹೇಳಿ, ಅದು ಏನಂತ ಫಸ್ಟ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು? ಇನ್ಫಾರ್ಮೇಶನ್ ಫ್ರಮ್ ಅದೆಲ್ಲಿಂದ? ಇಂಜಿನಿಯರಿಂಗ್. And all this is physically done. BDA has not implemented e-office. BDA has not implemented e-office. All the departments have implemented. You are not given access. You are not given access. Not original, for the digitized files. ಬೇರೆ ಎಲ್ಲ ಕೊಡ್ತಾರೆ, ನಿಮ್ BDA ಯಾಕೆ ಕೊಡಲ್ಲ ಅಂತ. ಅವ್ರು ಹೇಳ್ತಾರೆ, ನೀವು ಅವ್ರ ಮೇಲೆ ಜಂಪ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ಕಷ್ಟ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನಿಮ್ಗೇನೆಲ್ಲ ಕ್ಲೈಂಟ್ ಬಂದ್ಬಿಟ್ಟು ಎಲ್ಲ ಕೊಟ್ಬಿಡ್ತಾರೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ, ಅವ್ರ ಕಷ್ಟ ಅವ್ರಿಗೆ. ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್, ಅಭಿಮಾನ ಜಾಸ್ತಿ ಇರುತ್ತೆ, ಏನ್ ಮಾಡೋದು BDA ಮೇಲೆ. BDA ಡಿಸರ್ವ್ಸ್ ದಟ್ ಮಚ್. ಸೊ we will only record it and say the commissioner will have to take some action on it. We can understand the angst of Mr. Vasant Kumar also, because these are listed only once in a week. The moment it gets listed, if adjournment happens, it goes by 2-3 weeks. 7 years. And
we were trying to run up to the based on priority and so all the old matters are eligible. That's one of the reasons why I am not.
ಅದಕ್ಕೆ ನೀವು ಏನ್ ಟೈಮ್ ಕೇಳ್ತೀರಾ ಅದು ಕೊಡ್ತಾ ಇದೀವಿ. But this is 4 month old. This is not acceptable of 4 months. No, whatever time you ask, we will give you so that you file it.
I only as an intelligence I can tell you one of the papers I'm also thinking of
You file it. You file it will conceive. Unfortunately, what happens is once it is for listing, there are so many staff who have to work on it to list. It just takes a minute for adjournment. But it takes hours of work for people to even list it. So once it is listed, please don't take adjournment. Let us say this. Because adjournment are being sought for, we are listing so many so that at least something happens. ಏನು ನಡೆಯಲ್ಲ 50 ಹಾಕೊಂಡು ಎಲ್ಲ ಅಜ್ಜನ್ ಆಗೋದು. Shri B. Vachan, the council has been directed to take notice on 15/2/2022. Today also, he seeks for a short accommodation to file his objections. An inquiry as to why there is a delay in matters relating to BDA in filing of objections. He submits that for every objections that are required to be filed, there are multiple verifications which are required to be made at the land acquisition department, at the town planning department, at the engineering department, and the allotment department. We're coming to allotment department, depending on the nature of the matter. Since there are multiple verifications required to be done, it is taking considerable amount of time to get the details and file their objections. Correct. I have the considered opinion that it is high time that the BDA makes use of the information technology tools which are available, digitizes all the records, implements the e-office system, which e-office software, which is in use in other departments of the government. While doing so, when any particular council is allotted a particular matter, the council to also be given access to the digitized documents available with each and every department relatable to that particular litigation. The Commissioner, Bangalore Development Authority, as also the Principal Secretary, E-Governance Department, are directed to coordinate with each other to come up with a solution for implementation of e-office or a software of similar nature so as to solve this problem at the earliest. A report relating thereto to be filed within a period of 2 weeks from today. 3 weeks from today. Yeah, ಅದು ಬೇರೆ ಇವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಬೇರೆ ಬರುತ್ತೆ. ನಿಮ್ದಿರ್ರಿ, ನಿಮ್ದಕ್ಕೆ ಬಂದಿಲ್ಲ ಇಲ್ಲ. The Commissioner BDA, the Principal Secretary, Urban Development Department, and Principal Secretary, E-Governance Department. Correct. Shri B. Vachan is the said report to be filed within a period of 3 weeks from today, that is on or before 12/7/2022. Shri B. Vachan seeks for and is granted 2 weeks' time to file a statement of objections. The statement of objections to be filed on or before 7/7/2022, released on 12/7/2022. By the commissioner. We have commissioner here, but report to be filed by the commissioner BD.
The state may not also be told. This order so that they can also.
Should be. No, ಇದಕ್ಕಿಲ್ಲ ಇದು different departments ಅಲ್ಲ ಅದು ಬೇರೆ. That is for the application, Mr. Krishna. That is in cases of your other aspects which are there. Section 27. ಇದು ಇವ್ರ ಬೇರೆ ಕಥೆ ಇವ್ರದ್ದು. ಇದು ಬೇರೆ. Sri B.V. Krishna, learned AGA, is also directed to keep informed the Principal Secretary, Urban Development Department, and the Principal Secretary, E-Governance Department about the above order. The report to be filed by the Commissioner BDA. So he knows best what to implement. And 72 interim order. Phone number 3, other standing counsel is there. 3 other standing counsel is there. B.V. Krishna, there an AG accept notice for response number 1 to Manjunath and Bhaira Reddy. Then standing counsel is directed to accept notice for response number 2, issue notice to response number 3, returnable by 26/7/2022, released on 26/7/2022. Counsel for the petitioner to furnish copies of the petition along with annexures on the opposite counsels. Objections, if any, to be filed on or before 19/7/2022.
Appearing for the petitioner.
Yes, madam.
The lands were acquired for the formation of Bangalore-Hassan new railway board gauge through a preliminary notification, my lords. Subsequently, final notification was also passed, my lords, and the petitioner had given several representation with regard to non-granting of the compensation for Borewell and Malkis, my lords. Since the same was not considered, my lords, I had filed a writ petition in 13807 of 2016.
AGA is directed to take notice for response number 1. Sri Avinay Vaiti is directed to accept notice for response number 2 to 5. Counsel for the petitioner to furnish copies of the petition along with annexures on the said counsels. Objections, if any, to be filed on or before 8/7, relist on 12/7.
Please, my lords, much appreciated.
Classification of? This is public to message. What are you sought for in this? You are asking for lapsing of the scheme. How will this go as PP? Then that's a wrong classification. You have to get it rectified. If you asked for the same prayers, then that could not have been classified as PP. When you're asking for lapsing, you do needful in that matter, will order notice in this. Learned AGA accepts notice for response number 1. Shri Sandeep Patil, learned counsel, is directed to accept notice for response number 2. Counsel for the petitioner to serve copy of the petition along with annexures on the said counsel. Objections, if any, by 8/7, released on 12/7. Number identify ಆಗಿದೆಯಾ? ಎಲ್ಲಿದೆ ಅದು? 18. Site number ಎಲ್ಲಿದೆ?
Annexure D, no.
Page.
Page 12, 17. 44/1.
44/1 site number. I think the 44/1 baratte.
Division of money is 44/1. For which there is input has to be shown. And after the
There be a /1 number.
44/1.
Shri Amit Anand, when a standing counsel is directed to accept notice for respond number 1 and 2, counsel for the petitioner to serve copy of the petition along with annexures on the said counsels. In the meanwhile, respondents are restrained from allotting site number 44/1 as contained, as mentioned in annexure D to any third party until the next date of hearing. Objections, if any, to be filed on or before 8/7, released on 12/7. Shri K. Krishna is directed to accept notice for respond number 1 and 2. Counsel for the petitioner to furnish copies of the petitions also. Objections, if any, by 8/7, released on 12/7. Yes, Mr. Vinay. We need a list of all railway panel advocates. ಮತ್ತೆ ಹೆಂಗೆ ಕೊಡೋದು ಅವ್ರು ಕೊಡೋದ ಸೊ ನಿಮಗೆ ಆರ್ಡರ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅವ್ರಿಗೆ ಅದು ಅಭಿನಯ ವೈಕಿ ಅಂತಿರೋ ತೆಗೆದಾಗ್ತಿದೆ ಯಾರು MN ಕುಮಾರ್ ಕೇಳೋದ
One submission.
Yes, Mr.
Now central government, railways doesn't have a panel of advocate. Now the central government councils who appear, my lord, for the railways.
Whoever we direct to take, we will hold them responsible. That is your choice now.
No, that is what are the latest instructions. Now they don't have a panel, railways.
Are you a central government standing counsel?
Yes, I'm a senior central government counsel.
M. Unnikrishnan is directed to accept. You have to file your objection, Mr. Unnikrishnan.
Yes, serial number, my lord.
Serial number, 4.
Yes.
We are directed the counsel for the petitioner to serve it on Mr. Abhinay Vaiti. You contact and take the copies.
Yes, my lord.
Yes, Mr. Abhinay. Registration ಆಗಿಲ್ಲ ಅಂತ ಇವಾಗ ಅಲಾಟ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ. Shri S. Rajshekar, when a standing counsel is directed to accept notice for respond number 1 and 2. Counsel for the petitioner to furnish a copy of the petition along with annexures on said counsel. Objections, if any, to be filed on or before 8/7, released on 12/7. In the meanwhile, the respondents are restrained from creating any third-party rights over site number 1, formed in Belshantry 6th State, 7th Block, Bangalore, till the next date of hearing.
Appearing for the petitioner in this case, my lord, today I have filed wakalat of the managing trustee. The previous managing trustee had expired.
Why did you file it today, madam? Why could not it be filed earlier?
My lord, the managing trustee was not in India. He's arrived only yesterday. So he gave me a wakalat as soon as he's arrived, and I filed it today in the morning. If it may be listed
tomorrow, in 1 week he is coming. Now again adjournment. At your
even
cost.
if it is there listed tomorrow, we'll complete our argument.
Mr. Krishna, objections are done. That counsel for the petitioner submit that she has filed the wakalatnama of the managing trustee, present managing trustee,
Krishna Rajan, Rangarajan.
Shri K. Krishna, learned counsel for the respondent, submit that he has filed a statement of objections. Pleadings being complete, matter being of the year 2014, relist on 28/6/2022 for final hearing. Yes.
because I know only the last I have taken off 2 times.
So you have to find, you have to investigate and find the address. After third time, first you have to make, now if they have shifted to Andhra, what to do? If you take a publication in Karnataka. You verify malware. Otherwise your money will go waste. Then they will always come back and say we are not in that jurisdiction, even if you take paper publication. The risk is yours. ಸ್ವಲ್ಪ ಕಷ್ಟ ಪಡಬೇಕು. So, what about these objections on IA2 of 18? When counsel for the petitioner seeks for and is granted a week's time to furnish the current and proper address of respondent number 7 and 9. If the same is done, registry is directed to issue notice to respondent number 7 and 9, returnable by 26/7/2022, released on 26/7/2022. In the meanwhile, counsel for the petitioner is permitted to comply with office objections on IA number 2 of 18. Non-amendment of past title and non-title. Why does it take 21 days to comply with it, Mr. Shetty? No, 35 was the last order. 21 days. And undertaking was it to be done within 2 days from today. So 2 days on that, 19 days there, 1,90,000 cost. So Mr. Shetty is appearing. No, Mr. Shetty is appearing, so 1,90,000. Mr. Kannur is appearing, Mr. Ravi is appearing. So into 3 agbeku.
That I would agree with.
Straight? You also will pay. You also will contribute, Mr. Kannur. What is this?
I'm sorry,
It pains us because we are told that for each listing, 13 people have to work for one listing. And to adjourn this matter for, we won't use the word. Yes, Mr. Vachan, what about your objections? Professor Kumar, you are also appearing in this matter?
Yes, I am appearing for respondent.
Then 19 into 10. Professor Kumar is appearing weight of 6 allige. Avaru papa kaita.
I request the court to kindly peruse the order dated 4/10/2021 in writ petition 20150.
The BDA wants to file its objection, Professor Kumar.
No, they were also directed to give a sketch with the necessary information about the entire layout. The layout
writ petition
as 20150.
Dated?
See the order dated 4/10/2021.
Information and sketch showing the entire layout and lands which were earlier notified and subsequently denotified or dropped from the acquisition proceedings.
Yes.
You are appearing for Mr. Vachan, Mr. Kannur? You are appearing for Mr. Vachan? No. For R5, but for R4 in 2014. And the same person allowed in R5 allowed in 21. R5. ಇದನ್ನ ವರ್ಷ ಇದು 4-10-21 ವರ್ಷ ಆಯ್ತು. Uh, 2014, 2010 of 2014, correct. We'll come to the merits later. First, the house cleaning act. Objections you have filed in 20150.
Yes.
Now, what about the sketch and the details about the denotification and dropping of acquisition proceeding? So that is a sketch showing the entire layout. It is satisfied. Or dropped from acquisition. Very denotified, dropped to no. Petition allowed. There was an order passed by this court on 4/10/2021, which is yet to be complied with. We were telling Mr. Somshekara about 21 days or 19 days. Nimge ashtu months ge ಏನು ಹೇಳಬೇಕು ಅಂತ. Where is the list of lands? You have to give us a list of lands also, which are earlier notified and subsequently denotified. We will ask your engineering section to be in court and do it here. It takes 1 day if you wanted, Mr. Watson. Notifications illide, dropping illide, ಅಲ್ಲಿ ಬರೀ ಒಂದು ಮಾರ್ಕ್ ಮಾಡಬೇಕು ಅಷ್ಟೇ. ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಅದು? ಒಂದು ದಿನ. Then the efficiency of the staff at BDA we have doubted. So Vachan, all the information should be readily available with the BDA.
Should be available.
If BDA says I don't have the information, then who will have?
We cannot say that. That's not a submission that I can say. I'll be incorrect.
You've already taken 7 months.
I understand. I have to, what is available with me, I'll state it. To show that we are not being simplified. What is the modified plan is available. With respect to this 700, the entire document. The sketch prepared by the surveyor who is appointed by the BDA to show that particular area to effect that we have implemented this scheme as far as taking up the space. And so also the adjoining lands of the land, which is a question for your office.
Put it in writing, Mr. Vachan. Orally, you ಏನು ಹೇಳ್ತಾ ಇದ್ದೀರೋ writing ಅಲ್ಲಿ ಹಾಕಿ ಅಷ್ಟೇ.
details get verified from the engineering section with the new signature on the calculation. Along with the affidavit, all compliance.
If it is not produced, we'll draw adverse inference.
I understand.
It's up to you to produce. This order is only to inure to your benefit, to establish your bona fides. If you don't want to establish your bona fides and not controvert the averment made by the petitioner, adverse inference will have to be drawn against you. Yes, sir. Put it on paper. That's what the court has directed in October 2021. Like, orally, put it in writing. But without verification, you are making submission. Bad Angela, everybody.
I'll submit this. What happened initially was, we were told that we can make use of this. It's an evolving situation for us to delay. One of those attempts being made by the VDA to log the extent of the land which we are ahead and to what extent land we have developed. So one of those attempts being made streamlined.
We are really surprised at the submission that VDA will have to collate information. This should be available at the press of a button.
No, it is available. I'll not file it. Just to the ordinance, even number 2, and where order, I just place it.
What land is where you have formed the layout, it should be there as a real live, real time availability.
What my lord sees in a wavered pattern, some land which are not developed as a VDA. The one with the small boxes are the civic community. So my lord, the survey number, the dark thick dotted line are the survey numbers. The thin discontinuous thin red line are the bifurcation of the survey numbers. So this sketch is being done, has been done by one AI technology. But the insertion of the VDA that was done in the entire pattern. For each and every survey number is available. Now what we need to do that is we cannot write this identity. There are chances of human error. What we have now been doing about it, we make sure that this needs to go collaborated to the hard copies of the original file and confirmed by the competent officer. That I am getting it.
Is it a GPS survey, Mr. Vachan?
This is a GPS.
GPS total station survey.
What has been done, I am informed about it. The modified content plan of the DPM section has been imposed upon the and the other maps.
Village map madakagala nivu. There will be a lot of error. Have you conducted a total station GPS survey with a drone survey? Then it could be proper.
Drone survey, it will show the current situation. It will not provide us particulars of the implementation of this because we will not know who has reached or who has developed.
No, these are all layers. Village map is one layer. Village map ಇನ್ನೊಂದು layer is your layout plan. Other mele, it will be the total station survey as another layer. Other mele, next another layer would be the drone survey, which will give the actual status today. From all of it, you have to do it.
There is some process that we follow and it is done by the technology. To get information on what basically are but there's one of those being made by the streamline.
But how long do the petitioners and the court wait for this?
This is something that has not evolved. It's an evolving document. Say that. It's not something which is readily available on the ticket. I do not want the public to know without verifying it, which I will do. As far as the direction of
Mr. Vachan, the court gets blamed for delay. This is a 2014 matter. Even now you are saying you want time. The brickbats are for the court when it is the authorities who are taking time. So they have file material.
To show that I have implemented this. After my can you see that for a moment? The entire area
You want to argue on this basis, we'll take up the matter for argument. You want to have time, we'll give you time because you are an authority, but you tell us what time it will be ready. And no further adjournment after that. The 2014 matter. Learned counsel for the petitioner seeks for and is granted a week's time to carry out necessary amendment and file amended past statute. Shri B. Vachan, learned counsel for respondent number 1 and 2, seeks for 2 weeks time to file a statement of objection in WP number 11080 of 2021 and to comply with the order dated 4/10/2021 in WP number 20150 of 2014. It is but required for the BDA to place the necessary material as directed in the order dated 4/10/2021 at the earliest, since the matter has been pending from the year 2014. It is made clear that no further adjournment will be granted if the details are not furnished by (7/7/2022). The Commissioner, Bangalore Development Authority shall be personally present before this court on the next date of hearing, released on 12/7/2022. BDA irodu Tuesday ashte. So you will have all your BDA matters on 12th. 19th ಮಾಡ್ತೀರಾ? To be done on or before 13/7, released on 19th. Interim order is extended till next date of hearing. Okay. What is the objection in that? An objection.
Copy not, sir.
Have you served? The objection is that you have not served. Why can't you serve one copy on the council? Why does this have to happen? And only for that purpose this matter gets listed today. Serve it now. At least now have the courtesy to just say I am giving it now. Give it to them. One copy. Take out magic from your this one and say one more copy. Abracadabra and back to them. Copy. Counsel for. What's your name? Mr. J.P. Darshan, counsel appearing for proposed respondents in IA number 1 of 2022. Seeks for and is granted a day's time to furnish copy of IA number 1 of 2022 on the counsel for the petitioner and the other respondents. We list on objections. Any objections idya? Yaru anta gottidya? Objections, if any, to be filed on or before 29/30/6/2022, released on 5/7/2022. 28th or 5th? 28th was new objections ಆಗ್ತೀರಾ? Objections, if any, to be filed on or before 24/6, released on 28th. Shri N.R. Girisha has entered appearance for respondent number 1 and 2. Hence, registry is directed to delete the name of Shri K. Krishna as that appearing for respondent number 1 and 2. Registry is directed to connect the above matter with WP number, CL number 17375 of 2017. But we are not adjourning that matter as it. Only we are connecting right now. So when there seems to be some orders to be passed in that matter, we will pass that orders when it will be.
Lord, serial number 13, I appear for the petitioners. Milords, there are certain office objections were raised to which I have filed a memo, Milords, giving my explanation during 21st March 2022. I think that is placed before your lordships. May I submit, Milords? May I state the brief facts?
Yes.
Milords, the petitioners are aggrieved by the illegal sale of a corner site by the BDA this corner site worth more than 5 to 6 crores in the market today has been sold for rupees 4,500, my lords.
Now, who are you, Mr. Guru?
My lords, petitioners are neighbors of this site, which has been sold.
Public interest litigation.
Yes, my lords. That is the question. That is question number. I'm sorry, my lord.
Place it before the division bench.
Please, your lordship. My lords, actually another matter, connected matter, WP number 17856 bar 15.
17856 bar 15.
Yes, my lords. This was heard by a learned single judge, and it was part heard, thereafter released from part heard, my lords, after filing of this petition. So may I pray that this same will be heard along with that, my lords. My lords, in that petition.
What is the relief sought for in that matter?
Please, my lords. My lords, this was a corner site in an otherwise fully completed residential locality. This corner site was being used as a dumping
what
yard.
What is the relief sought for in 17856?
17856, my lords, it was for a direction to the BDA and the BBMP to act on the representation of the petitioners to issue notice to the owner of the corner site to fence the site and to clean the site. Instead, my lords, what they do is, because this site had not been allotted to anybody, they bifurcate the corner site and sell it for 4,500 rupees, my lords, giving rise to this present petition. My lords, in the earlier petition, Mr. B.S. Sachin used to...
We'll place it, it's a PIL, Mr. Guru. We can't,
Yes,
we don't have jurisdiction. We'll place it, you can argue that.
Please, my lords, please.
The perusal of the allotments and the prayer which has been sought for indicates that the present petition is in nature of a public interest litigation.
Yes.
Hence, the Registrar Judicial is directed to place the matter before the appropriate bench handling public interest litigation relating to BDA. Sri Vijay Chandra Guru, Learned Counsel, submits that there is another connected matter in WP number 17856 of 2015. Registry is directed to connect the above matter with WP number 17856 of 2015.
14, I appear for the petitioner in this matter, my lords.
Yes.
Office objection, my lords, pertains to certain typed copies of manuscripts to be produced. Only one manuscript I have produced, my lords, which is an encumbrance certificate. It is only for collateral purpose.
Page number?
My lords, it is as annexure E, my lords, at page number 38.
Yes, good.
My lords, the case is not, my lords. Lords, the case of the petitioner is that, my lords, his father always...
AGA accepts notice for respond number 1. You accept notice in instructions as well. Should B.S. Sachin accept notice? Should B.S. Sachin, Learned Counsel, submits that he has already filed Wakalatnama in the matter, registry to verify and print his name as that appearing for the respondent. He seeks for and is granted 2 weeks' time to file a statement of objection. Objections, if any, to be filed on or before 8/7. We list on 12/7.
Achha.
Interim application, both of us have filed for an additional document. That it should be taken up along with final hearing.
Mr. Panindra, you are appearing for 14 and 18.
Right.
What about 13? Mr. Kiran Kumar had filed caveat for 13.
Okay, 18 will actually take care of.
Now, what happens to 13? Because
13 is dead.
caveat had been filed by Kiran Kumar for 13 and 18.
13 died on 12/4/2019.
Your instructing counsel has appeared for 18. So 13 then, no, you don't want to bring the legal.
14 is on record on your.
Has 14 been treated as such? Shri Ajesh Kumar, Learned Counsel for the petitioner, submits that on the expiry of respondent number 13, respondent number 14 has been treated as a legal representative of respondent number 13. Then the registry direct delete the name of Shri Kiran Kumar DK as that appearing for caveat respondent 13 and 18. More so since respondent number 18 is now represented by Ms. Vaishali Egde, Learned Counsel. So we are 10 and 11, we are Jagdishwarana, Shankar Narayana.
Jagdishwara, my lords, I am on record, my lords.
Sri N.R. Jagdishwara has entered appearance for respondent number 10 and 11, and registry directed delete the name of Sri B.V. Shankar Narayana is that appearing for 10 and 11. So Sadashiv Reddy or Restu delete madbeka R18 ge. R18. ಮತ್ತೆ ವೈ ಆರ್ ಸದಾಶಿವ ರೆಡ್ಡಿನೂ ಇದೆ Indian line. Since Ms. Vaishali Hegde has entered appearance for respondent number 18, registry is directed to delete the name of Y.R. Sadashiv Reddy as that appearing for respondent number 18. Lakshmi Rao Aito. 14 to 17. 14 to 17 and dispensed with for 19 to 22. 14 to 17 arrow.
14 I appear a lot. 14 and the
14 I 15, 16, 17.
17 is dead. 17 is dead. 17 is by the
Who is representing them? Is held sufficient 17.
Yes.
Or minor represented by 17. What about 15 and 16?
15 and 16 already served.
Who appears?
After remand, I do not know, but I am not complaining for this.
Okay, whenever on the left and right, there are so many things you need to clear them up. Otherwise, final dictation of order is just messy.
In fact, since Manindra plan 18, it's a subsequent purchase, you would represent the entire estate. What happened, my lord?
No, we just want to know, Mr. Ajesh, what happens to 15 and 16? So we have account for 1 to 11. 1 to 11 we have account for. 12 we don't have an account for. 12, 19 to 22 are dispensed with. So that also is fine. 13 Aito, 14 one row. 15 and 16. $17 ಆಯಿತು, 18 ಆಯಿತು, 19 to 22 dispensed. So 15 and 16 are the ones remaining. And Mr. Kiran Kumar is not here.
Probably remanded, so I do not know whether he is going to.
So if it is a remand matter, do we need to issue notice?
That is to say that he is filed, but it's a remanded matter.
We have to issue notice. Who are here are here. Who is not here, what to do? So this is a direction by the Supreme Court. We don't want at last stage that it gets adjourned on that matter.
Not long earlier, if somebody had appeared to them.
After remand, Mr.
No, after remand. Because the other person, the LR's notice was issued and the petition was subsequently amended.
And ask your instructing counsel to go through the file and tell us who is appearing for who. So at 2:30 we can pass a detailed order on it. If notice has to be ordered, we can order notice. If you can get Mr. Kiran Kumar to appear also, good, whatever you want to do.
I'll just go through the order sheet.
Pass over.
Sorry, this one was submission. The last year, when we went on the commission, with reference to which the government could adjourn its signed it. I just wanted to make a clear submission. Those two are completely disconnected. Ultimately, it is.
Oh, this was that matter which we adjourned, then you had mentioned. And then we did it.
I want to say is at every stage they would come up with something interesting. Not to protect, we are going to. We are not. I just tell my lot on facts.
We don't need to get into that now, Mr. Ajesh. Mr. Pranindra is very fairly and gracefully agreed that it is not so. So now we get all the people, we'll take it up and dispose the matter. Let's go to that stage. So 2:30, you let us know which counsel appears for whom, who has expired, who are the legal heirs, are they represented, not represented, whom notice has to be issued. Let us finish that.
Takes up our submissions will be there, but he can't create.
no point in hearing bits and pieces until we have this done. Now, there are two proposed respondents, IA 1 of 22 and IA 1 of 21. That petition. We'll allow the impeding application also connected. Anyway, it's the same thing. It anyways to his benefit. Minimum writ petition number.
16,000 to 16.
You have filed your objection, Mr. Krishna? Shri, accepting the reasons stated in support of IA 1 of 2022, the same is allowed. The person named therein is brought on record as respondent number 4 already there. Respondent number 4. Accepting the reasons stated in support of IA 1 of 2021, the person named therein, the said application is allowed. The person's SJNA is IA 1 of 21. First IA 1 of 2021 is allowed, brought on record as respondent number 4. Accepting reasons, IA 1 of 2022 is allowed, brought on record as respondent number 5. Counsel for the petitioner is directed to carry out necessary amendment and file amended past statutes. Objections, if any, by the impleaded respondents to be filed within a period of 2 weeks from, within a week from, then counsel for the impleading applicants, impleaded respondent seeks for and is granted a week's time to file a statement of objections. All the counsels submit that the above matter is also connected to WP number 16216 of 2016. Registry is directed to connect the same with the above matter and relist on 12/7. Interim order earlier granted is extended to next year.
21 is already dismissed.
Dismissed. IA 1 of 21 is dismissed. That in my list of
22 ಮಾತ್ರ ಬಂದಿದೆ.
Okay. ಮತ್ತೆ ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
22 ಮಾತ್ರನೇ ಲಿಸ್ಟ್.
1 of 2022 is allowed, respondent number 4 after. What about payment of cost? Counsel for the petitioner seeks for and is granted a week's time to file necessary proof of payment of cost. ಬಂದಿಲ್ಲ, ಇವ್ರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ಮಾಡಿಲ್ಲ. ನಿಮ್ ಫೈಲಲ್ಲಿ ಇಟ್ಕೊಳ್ಳಿ, ಇಲ್ಲೂ ಈ ಫೈಲ್ಗೂ ಬರ್ಬೇಕು. ಫೈಲ್ ಮಾಡಿ.
I appear for the respondent, my lord.
Yes. Ready, Mr. Unikrishnan?
Yes, my lord. In the last occasion, this honorable court had directed that the other petition, my lord, which was disposed of the act.
23216 is kept below. What is other 23216?
But I had submitted, my lord, that the property, my lord, in a partition goes to that person who had filed a petition, and he had withdrawn the.
No, because 11217 has been filed, he has withdrawn it, Mr. Unikrishnan.
But my submission is this, my lord. As far as this petitioner is concerned, she would not be the owner of the property and cannot maintain this petition by virtue of the fact that in the partition, her son has got this property.
That is on merits we can go to.
Yes,
The last contention is because the earlier petition has been dismissed, the second petition is not maintainable and therefore. On
Yes.
merits, whatever you want to make your submission, we'll consider that.
Yes, on merits also I'm ready, my lord.
But disposal of 23216 will not come on a preliminary matter, it won't come in the way of this petition.
My submission, my lord, is that to maintain a petition even, she has to be the owner of the property, prima facie.
As a merit, sir.
Yes, my lord.
Preliminary objection illa.
Yes, my lord, then this matter is taken up on merits. Okay.
Yes. Yes. Pass over, beta. Pass over.
Pass over bill on date quota, Swami.
Pass over, Muksana, Mr. Unikrishna. You are
Cross
ready.
examination, civil court is on the work.
High court ante.
One day, I'll go on with that. I'm ready. I filed my objections.
Cross examination in the forenoon session. This will be after 2:31.
My lord, even then, my lord, I'm ready. That it will go on for something. That is why. Plan my day.
Counsel for the respondent 2 and 3. Learned counsel for the petitioner seeks for passover. Learned counsel for the respondent number 2 and 3 seeks submit that the matter may be adjourned. Released on 5/7. 28/6.
Right, 28.
Yes, madam, any of this? This site has been transferred to Slumbo. How does BDA transfer it to Slumbo? How does BDA transfer it to Slumbo? Unless it is a scheme under the slum development. Or copy ಕೊಟ್ಟಿದೆ. How would this site get transferred? It was allotted for, is it a allotment for EWS?
Yes, allotment. Coming to the fact, merits of the case, I prepared a statement of objection and I found that it was a temporary possession certificate is also produced by the petitioner. That temporary, and he has agreed, he has executed the possession, executed the agreement for a period of 5 years. That later on, after his death, his wife supposed to be has filed a application. That has not been considered because the husband name is shown as a different one. Ramaya. Instead of Ramaya, it is shown as Malayo on the part. Thereafter, the present petitioner, Krishna, has filed this application stating he is the owner, legal heir, but he has not produced any legal heirship certificate or the family tree to show that he is the only heir who can be.
You consider it and they can always furnish documents, you pass orders.
Actually, I can file a statement because the statement is ready. On that basis, your office can. I will file it also.
This is only to consider, they consider a representation. You consider it in accordance with law and pass orders, then they will challenge it.
In the name, on 28 or so, 28
Madam, there is a
Statement signed by the party.
we understand.
Including this.
There is a representation given in the year 2018.
Yes.
Your officers did not have a courtesy to pass any orders till now, until notice was issued to them. Let them show the courtesy of passing orders on the representation.
I have filed a statement along with this notification.
But we are not going to adjudicate the matter in a mandamus manner.
Yes, but I filed a statement of intention because it is ready. I think
You do that. You do that. But we are going to issue a manual directing you to consider. Yes, while filing the statement of objection, please also explain why it took 4 years for you not to pass an order. Wherein counsel for the respondent seeks for and is granted a week's time to file a statement of objection. It is made clear that the statement of objection would also require to explain the delay of the officers of the respondent in not passing orders on the representation given by the petitioner in the year 2018. We respond 28(6). So, Shri Prasad, Mr. Vijay Kumar. IA1 of 2022 does not survive. When counsel for the petitioner submits that he does not press IA1 of 2022, hence IA1 of 2022 stands dismissed. Merit, sir? Ready? Good. What was the reserve price? 1 lakh? So you have quoted 1,54,000. Yes. ಅದು ಕಾಣಿಸಲ್ಲ ನಿಮ್ಮ ಟೈಪ್ ಕಾಪಿ 21 ಇದೆ. 19 the type copy 21 ಆಗಿದೆ. ಎಲ್ಲಿದೆ 21 minimum rise in the box.
They don't mention anything about 5% over bid price, namely 1 lakh. Initial bid is 1,20,000 per square. There is no prescription that it could be any rise could be minimum of 5%.
Yes.
Minimum range could be 500 rupees per square.
Yes.
There are 2 persons in the bid. Which are produced along with my advisor.
Only 2 persons participate.
Paragraph 2 of my agenda, one Mr. Muralidhar Bhatwat also participated. He went on, both of us kept on giving 500 rupees more per square meter. Ultimately, I have the highest bidder. At 1,54,000, you will actually to find a page 2 of my result. Then I also produced the
1,54,000 ಅಂದ್ರಿ, ಬಟ್ ಇಲ್ಲಿ 1,79,500 and third. In para B. You are saying in para 1B, so the petitioner was also a participant in the said auction in relation site number 176 of HSR layout 4. Second, offered his bid at rupees 179,500 per square meter.
My offer should have been 5% of 1,79,500. Not at 1,54,000.
Yes.
My 1,59,500. What I have quoted is 1,54,000 per square.
What is the site number, 176 or 276?
Another side, I also bid that another side. I was a successful buyer. But if there was several bidders there, bid was competitive. I had to bid there was a better side than this. This is near the grave. Therefore, I offered 1,54,000. Now the question is this now. So I rejected my offer without assigning any reason. No reason for that. Now what I want to say is 5% minimum of the bid amount should have been given. Otherwise, you won't accept it. According to an auction committee. It is not forthcoming either in the tender notification or any of the portal for the media. They were not informed about it. Nothing about that. Because they were calling for any objections.
What was accepted? What has been accepted? Yours is rejected. So the other person's bid is accepted?
No, mine was not also accepted.
So both the bids are rejected. Nimdo. What about the Mr. Murlidhar?
No, I was the highest bidder. How does that happen?
So has it been accepted?
No, not accepted.
So nobody's is accepted.
No, if the auction is unaccepted at face guarantee, there won't be any reason. Reason for not forthcoming. No, they want to supplement the reason to the reply, saying that there is an auction committee. According to the auction committee, there are instructions that the bid amount has to be 5% over and above the initial bid. Therefore, we don't accept it. You have made it another for another site for which you have offered more than what you have offered here. But there the competition was very tough. There are other bidders also there. And they take shelter under clause 13 for the auction notification.
Or it can withdraw.
They have the right to
Reject.
reject the offer without assigning any reason. Directives say 22.
Yes.
One of the conditions are that we have the right to reject it. That is at least 20. We not assign anything. That means also 13, the general condition. The difference would be this now. To calculate it, 154. What I offered is 5 crore 61 lakh for the site. To take 5% over 150, it will be 1,57,500. The difference is hardly about 13 lakhs. Because I was prepared to pay. Because the expedition I have said, because of the 5% increase, I'm prepared to pay the amount also. 13 lakhs would be different.
Yes, Mr. Krishna. Where do you get this? Where do you get this 5%?
That is less than 5%. 5% is because the extent the payment is less than 5%. So it is not the rate expected by the. Therefore, we have single bidder.
Where has BDS said what is the rate expected? If you have said that each upward revision has to be 5% above the last, then we understand. What you have said is 500 rupees.
That is a
Minimum raise of bid price is multiples of 500 rupees per square meter.
Multiple of 500.
Hmm.
Yes. Here, there is only single bidder, not taken by the petitioner, two bidders. One bidder is in the technical bidder, is actually only one bidder.
Then you can't have a bid only.
No, we have bidder, it is not in the expected price, the kind of group 3 and room 7 of the class 13 of the page 20.
Adaittu,
Group 7 also says BDA disposal of partner size and commercial size.
If there's only one person, then you can't have a bid. Then you'll have to redo the whole thing. You should mention that reason, Mr. Krishna, when you send them. Yes.
Decision of the authority. The authority shall have the right to confirm or cancel any sale in auction without assigning any reason. And when the sale is cancelled, the amount received from the auction purchaser as deposited shall be refunded to him.
We will introduce one High Court rules or one rule introduce. High Court can allow or reject any petition without assigning any reasons. Simple, is old idea. Can a statutory authority say that I will do whatever I want? Yes. But what is your decision? We are not concerned with the decision. We are concerned with the decision-making process. So let us see what is your decision-making processes.
Process is concerned, I have mentioned in my statement of this one at paragraph 103. My statement of this.
Yes.
It is submitted that in the auction proceedings, the bid amount quoted or raised by the order bidder is not visible to the BDA or the auction conducting officer. And first, our bid amount the BDA or the auction conducting officer will come to know the bid amount only after the closure of the bid. Upon opening the bid, the same will be placed before the auction committee. The committee constituted for such auction. The auction committee, after considering that the petitioner was the sole bidder and the highest bid amount quoted by the petitioner in respect of the site number 273 HSR was 1,54,000 per square meter, which is the less than the 5% of the minimum bidding rate quoted by BDA for the said site.
Where is this 5%? From where did you get this 5%?
He is raised 4,000 rupees. It is 4,000 rupees, less than the 5% of the 1,50,000.
Where do you say 5%? Where are you getting this 5%?
Highest bid is the minimum price is 1,50,000. He quoted maximum price 1,54,000. 4,000 is less than the 5% of the 1,50,000.
Correct. Mathematically, correct. It's less than 5%. But where are you getting this figure of 5% to be given? Where is the mandate for him to be 5% above 1,50,000? Which rule, which notification, which provision?
5% is concerned
mathematically, there is no doubt about it. But where do you get this 5%? Was the petitioner informed about it? Was it a term of the auction? Really, they thought so.
General terms and conditions of the auction.
Really, the 5% is
5% is but earlier 39 the BDA reserves the rate of
that is so we'll also, without giving reason, allow the petition. We'll apply your rule 13. One minute, just 1 moment, Mr. Vijay.
Which I got for last condition. Your ultimate take idea for case. One which your ultimate not that's not supposed to. And they take the option modification. When it comes to the general terms and conditions for the auction. But when para 23, clause 23, no, that if you're not available, then existing at that time. So what is what? 23, league interest money. 5% of league percent. For all the auctions, present period, 5%.
How do you hold a bid when there's only one bidder? There is no auction.
The dishonorable court will let the owners consider if it is rate is lesser than the we expected, they can re-auction it.
Then we should fix it with the higher reserve price. If your expectation is X amount of money, fix that as reserve price. You can't offer something at a particular price and say now even if a person offers that price, no, we expect higher price. Your reserve price is what you expect. Then you fix the reserve price, Mr. Krishna. You fix your reserve price as 2 lakhs. That's your choice. If somebody is going to bid for 2 lakhs, they'll bid. But you cannot say I'll bid 1 lakh, I'll fix it at 150, but I won't sell it unless I get 179. You can't then have that. Then you fix that. After that, the minimum raise is going to be 5%. You fixed it at 500 rupees. Have you conveyed your expectation to anybody? Where is this expected? What is this concept of expected price, Mr. Krishna? Unless it is made known. If you follow an opaque system of expected price, tomorrow somebody will come and say my expected price is 2,10,000. Day after tomorrow somebody will say it is 2,25,000. Expected is the reserve price, that's all.
We have the right to, under the rule also, we have the right to cancel if it is.
You are a statutory authority, you have to give reasons. You cannot reject just like that.
The judgment by the judgment after following the Supreme Court judgment, the judgment was read from the para 3 onwards.
Yes.
On the other hand, the other counsel appearing for the response submit that the average expected auction price in the locality is 18,000 to 20,000 per square meter. The expected offer for site number 108 is 45 lakhs to 50 lakhs. And in respect of the site number 109 is rupees 28 lakhs to 31 lakhs. Since the offer is in respect of the site number 109 is 35 lakhs and respect of site number 109 is 25 lakhs 59,000, which is much lower than the expected offer. The respondent has rejected the offer of the petitioner and cancelled the auction of the said site. It is argued that the bid has been rejected with the view to get a higher offer and consequently to get more price, which ultimately would be in public interest. I have carefully considered the argument made by the learned counsel at the bar and perused the material on record. As noticed above, the respondent issued an auction notification as per Annex A, proposing to auction the proposed two sites. Clause 6 of the notification clearly stated after bidding, the right to accept or reject the bid is reserved by the commissioner. The case put forth by the respondent is that the expected auction price in the locality is 18,000 to 20,000.
We will call for all these details in this matter, Mr. All the details as to what was auctioned, at what price it was auctioned, you'll have to produce all the details. This is not the way that you can fix a price and then say my expected price.
Fixed price, it is only minimum price. You can secure the highest.
Then secure, you have not been able to secure, you have only one bidder. Secure it by fixing the reserve price, Mr. Krishna, not otherwise. You want to fix it at 2 lakhs, fix it at 2 lakhs. Fix it at 10 lakhs. Who bothers? You get it for 10 lakhs. But having fixed a reserve price, then you say I have my expectation. Who knows about your expectation?
The minimum price fixed and they asked setting the judgment on the locality price, we expected is locality price.
Then why did you fix it at 150?
That is the minimum price for the every auction we have fixed.
What is the sanctity of it, Mr. Krishna? Fixing the minimum reserve price. There must be some sanctity. ಇಷ್ಟೇ ಪ್ರೈಸ್ ಕೊಟ್ರೆ ನಿಮಗೆ ಸಿಗತ್ತೆ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಅಷ್ಟು ಕೊಡ್ಬೇಕು. ನೀವು ಬರೀರಿ ಮಿನಿಮಮ್ 5% ಅಂತ ಬರೀರಿ, ಯಾರು ಬೇಡ ಅಂತ. ಬರೀಲಿಲ್ಲ ಅಂದ್ರೆ ಯು ಕ್ಯಾನ್ ಲೇಟರ್ ಆನ್ ಚೇಂಜ್ ದ ರೂಲ್ಸ್. ನಾಟ್ ಫೇರ್. ಅಥಾರಿಟಿ ಡೂ ದಟ್. We don't know whether BDA acts for public benefit or not. That's a different issue. But definitely this is not the way that the BDA can act. So, petitioner is before this court seeking for the following release. The first respondent BDA had issued an e-auction notification on 4/9/2020 for e-auction of sites and various layouts found by it in Bangalore. The petitioner had participated in the e-auction of site bearing number 276 in HSR 4 sector Bangalore, measuring 15 meters into 24.30 meters, totally measuring 364.50 square meters. Right. The initial bid price fixed for the said site, as per the notification issued by the respondent, was rupees 1,50,000 per square meter. The petitioner bid an amount of rupees 1,54,000 per square meter. However, the same came to be rejected by the respondent by an email dated 28/9/2020. It is agreed by the said email that the petitioner is before this court. Shri R. Vijay Kumar, learned counsel for the petitioner, submit that the endorsement by email at Annexa A, dated 28 September 2020, does not afford any reason except to state that the offer made is rejected and there will be a refund initiated of 4 lakh rupees which had been remitted. He submit that it is required of a statutory authority to at least provide some reason for rejecting of a bid instead of acting in an opaque manner by rejecting a bid which is being rightfully submitted without providing any reason. He submits that after the petition was filed, the respondent has filed its statement of objection, wherein it is contended that wherein the reason has been given that the bid offered by the petitioner is less than 5% of the minimum, 5% over and above the minimum bidding rate fixed by the BDA. Such a ground is not tenable on part of the respondent inasmuch as no such condition has been fixed in the e-auction notification or in any of the rules relating to disposal of corner sites, more particularly in covered under the BDA, bracket disposal of corner site, etc., rules 1984. He therefore submits that the reason now attributed as regards the bid of the petitioner not being 5% over and above the minimum bid, not being envisaged either in the e-auction notification or in the rules, such a reason for rejection is completely arbitrary, illegal, and cannot be sustained, and therefore he submits that the petition is required to be allowed. For contrast, Shri K. Krishna, learned counsel for the respondent, submits that in terms of clause number 13 of the general terms and conditions for e-auction, the BDA has reserved its rights to accept or reject the bid made by the successful bidder without assigning any reason. And as such, the BDA, being competent to reject any bid, has rejected the same, and there is no reason which is required to be given by the BDA. In this case, there was only a single bidder, and therefore the BDA has rejected the bid. As per Rule 7, single bidder antidia. Not a single bidder. He also relies upon Rule 7 of the BDA, disposal of corner site, etc. rules. To contend that the authority, that the BDA shall have the right to confirm or cancel any sale in auction without assigning any reason. And when the sale is cancelled, the amount received from the auction purchaser would be refunded. Thus, the rules that's the sale notification, as also the rules providing discretion to the BDA to reject any bid furnished. The BDA has acted in the right manner. Thirdly, he contends that the BDA expected a sale price of at least 5% over and above the expected price in. At least on the minimum. A minimum of 5%. And then your contention is that the bid has to be at least 5% over the minimum bid price fixed. Thirdly, contends that the minimum bid price has been fixed at 1,50,000, and the bid offered by the petitioner being 1,54,000 is less than 5% of the minimum bid price, and as such, the same is below the expected price of the BDA, and as such, the rejection made by the BDA is proper and correct, since the BDA has proposed to sell the corner site in public interest for making use of the monies received for public purpose, and BDA expecting that there would be a better price which would be received, has rejected the bid. Those are the conditions. Third, Shri R. Vijay Kumar. Annexure D, page 13, along with your rejoinder. In rejoinder, Shri R. Vijay Kumar, Learned Counsel submits by referring to Annexure D to the rejoinder filed by him, which is the details of the details printed from the dashboard of the e-auction, that there was not a single bidder. Last paragraph. So there were two bidders relying on the dashboard maintained by the BDA. There were two bidders. One, Shri Murlidhar Bhagwat had bid 1,53,500, and the petitioner had bid 1,54,000. There being no further bid by Shri Bhagwat, he submits that the auction should have been closed in favor of the petitioner. He further submits that Mr. Bhagwat had bid 4 times from 150,500 as the first bid, from a second bid of 151, from a 500, third bid of 152, 500, and the fourth bid of 153, 500. Whereas the petitioner had made his initial bid of 151,000, followed by 152,000, and the third bid being 153,000, and the last bid being 154,000. Therefore, on the basis of the above, Shri R. Vijay Kumar submit that there being two bidders, the contention in this regard of the BDA is also not correct. Third, Shri R. Vijay Kumar, learned counsel appearing for the petitioner, Shri K. Krishna, learned counsel appearing for the respondents. The short question that would arise, the questions that would arise for determination are: one, whether the BDA can reject, BDA, a statutory authority, can reject any bid received without providing any reasons by relying upon a condition of the auction and or Rule 7 of the BDA, disposal of corner site, so and so rules 1984. Two, whether the BDA can reject a bid submitted by a bidder on the ground that the bid submitted by the bidder is below the expected price of the BDA. I answer the above questions as in the point number 1. It is true that there is no dispute that in the e-auction notification, clause 13 confers a right on the BDA to reject a bid without affording any reason. Rule 7 of the BDA rules 1984 reads as under. Though these rules provide for the BDA to reject the bid, I am of the considered opinion that the BDA, being a statutory authority, being a public authority, discharging public functions, and the properties being auctioned being public properties, the participants being the general public, it is but required that the BDA exercises any powers vested with it in a reasonable manner by giving, and any decision taken by BDA and or its officers would have to be accompanied by reasons. The BDA cannot, by referring to a particular clause in the e-auction notification and or Rule 7, contend that there is unfettered discretion vested with the BDA to accept or reject a bid without providing any reason. It is not only the decision, but it is the decision-making process which would be relevant, and it is only when reasons are given that this court could ascertain if the decision taken by the BDA and or its officers are proper and correct. If no reasons are given, then there is no manner of ascertaining whether the BDA and or its officers have acted in a proper manner or not. In the present matter, a reading of Annexure A reads as under. Inverted commas. Dear Sir, stroke Madam, comma. This is with reference to auction site number 276 in HR page 17. A perusal of the above only indicates a reference to the site, e-auction notification, and the decision of the BDA that the offer made is rejected. There are absolutely no reasons which have been provided in the said rejection. If the contention of the learned counsel for a respondent is accepted, then whether the offer is made for 1,54,000 or for any higher amount, the BDA could have rejected without affording any reason. There would be the same would be a complete violation of the Constitution of India, more particularly Article 14 thereof, where any authority is prevented from acting in an arbitrary manner. The manner in which the decision has been taken by the member, the finance member, BDA, while the aforesaid email suffering from lack of reasons cannot be sustained. Even where there is a right vested with the BDA to reject a bid received either under a clause to the e-auction notification or under Rule 7. I am of the considered opinion that reasons have to be ascribed to the decision which has been taken. Point number 2. The second contention urged is that the price which had been offered by the petitioner at rupees 1,54,000 was below the expected rate, and or that the amount of rupees 4,000 above the minimum rate which had been offered by the petitioner was much less than 5% over and above the minimum rate fixed by the BDA. A reading of the e-auction notification does not indicate in any manner as to the expectation of the BDA that the bid which is received by the BDA has to be at least 5% over the minimum price fixed. The e-auction notification only indicates that the minimum raise of bid price has to be in multiples of rupees 500 per square meters. Since the bid price which has been fixed, minimum bid price which has been fixed is 1,50,000, the next bid can start at 1,50,500 and so on and so forth. There is no particular requirement that in the e-auction notification that the final rate after all the bid is completed is at least 5% over the minimum price fixed. The very purpose of fixing the minimum price is the minimum expected rate by the BDA. It was always open for the BDA to fix a higher rate than 1,50,000. Having fixed the said rate, if the BDA cannot be heard to contend that the expected price was 5% above 1,50,000 and the fixation of 1,50,000 does not bind the BDA. The BDA, in my considered opinion, the BDA having fixed the minimum price at 1,50,000, any price over and above the set price quoted by any bidder would comply with the said requirement, and any price over and above that being final with no other bidder bidding more than that would be required to be accepted by the BDA. In view of the above, I answer point number 2 as well. In view of the above 2 answers, I pass the following order. Repetition is allowed. A certiorari is issued. The endorsement as per Annexure A, dated 28/9/2000, issued by second respondent to the petitioner in respect of site number 276 of HSR 4 sector Bangalore is hereby quashed. The second respondent is directed to confirm the bid of the petitioner as being the highest bid and execute necessary sale deed as per the price tendered of rupees 1,54,000 within a period of 4 weeks from date of receipt of a copy of this order. In terms of the option. Why, Mr. Ajay? In your statement, you filed your statement? Filing. So when will you file? When will you file it?
2 days.
Shri Ajay Kumar, the counsel. Wakalat Kakilana. Shri Ajay Kumar Leonard Counsel submits that he has filed Wakalat registry to verify. He seeks for and is granted 2 days time to file a statement of objection after serving a copy thereof on the counsel for the petitioner. We list on 28. Accepting the reasons stated in support of IA-1 of 2020, the production of original stock certified copy of Annexure C and E is dispensed with. IA-1 of 2020 is allowed. Accepting the reasons stated, production of a certified copy of Annexure A is dispensed with. Does Mr. Basraj? Ready? Objections active? Ready in the objections. Ready? When did you deposit? Dated. Not in dispute. Okay.
After depositing the amount, they have issued an allotment intimation letter as per Annexure J. And inform the petitioner that the site is to be withdrawn. And inform that they are not to the permission certificate.
Your India domicile certificate is an Delhi. ಅದಾದ್ಮೇಲೆ ಏನ್ ರಿಪ್ಲೈ ಏನಾದ್ರು ಕೊಟ್ಟ ಯಾವಾಗ ಕೊಟ್ರಿ ಡೊಮಿಸೈಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲಿದೆ ಡೊಮಿಸೈಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ನೀವೆಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲಿದೆ
ಹಂಚಿಕೆದಾರರಿಗೆ ಈಗಾಗಲೇ ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡಲಾಗಿದೆ. ಪ್ರತಿಯೊಂದು ಪುನರ್ಸಂಖ್ಯೆ ಹಂಚಿಕೆದಾರರ ಮನವಿ ಪತ್ರದಲ್ಲಿ ಮೂಲ ವರಮಾನ ಪತ್ರ ಮತ್ತು ಪಾವತಿಸಿದ ದೃಢೀಕರಣ ಪತ್ರ ಮತ್ತು ವಾದ ದೃಢೀಕರಣ ಪತ್ರ ಮತ್ತು ಗುಣಾಂಕ ಪುರಾವೆ ದಾಖಲೆಯಾದ ನೀಡಿರುತ್ತಾರೆ.
This was on 24/2/2007.
The allotment came to be cancelled on the ground that he is having a site before that having a site will be Annexure R1.
So you've been allotted a site in Arkavati.
Yes, I have not allotted a site either with the BDA or any other authority. Any other authority like a system. Let's do it as one site plus I think to purchase by the petitioner or petitioner husband in year 1974 itself. Okay, and that way the allotment came to be.
If you own a site, you own a site. Ashta. There is only BDA gives only to people. EWS came only who don't have.
Yes, I have not. I have not allotted a site by any scheme. I have not allotted a site by any scheme. This is like purchased by.
New declaration kodbekala. Say that I don't have a site in Bangalore. Me or my family doesn't have a site. Rule 10 of? Allotment of sites. Yes. Really?
Who are any member of the family who stay at a house, been allotted a site and house, they value what they have. Or will the office of the system of the art of office or any other value property.
Owns a site or a house or has been allotted. Owns a site or a house. Or allotted.
No person who are any different members whose family owns a site or a house or has been allotted a site.
Small or big, yak tonapur. Tonra mugi.
So many persons they have allotted a site, they have 3 or 4 sites in one.
As a Public Interest Litigation Act. ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ಇದು ಮಾಡಿಬಿಟ್ರೆ ಆಮೇಲೆ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಬಿಡ್ತಾರೆ. ಈಗ ವೈಲೇಟ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ, ಆಮೇಲೆ ನಮ್ಮ ಆರ್ಡರ್ ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ. ಒಂದು PIL ಹಾಕಿ, ಅಲಾಟ್ಮೆಂಟ್ ಒಂದು PIL ಹಾಕಿ, ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡ್ಬೋದು. ಇಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. There's an admission by you. What is more? No purpose would be served. Empty formality. You have admitted that there is a site. So, petitioner is before this court seeking for the following release. The petitioner husband had filed an application before the respondent BDA for allotment of a 20x30 site under EWS category. Site number 695, measuring 20x30, situated 14 block Arthavati layout under the EWS category had been allotted to the petitioner. However, since the petitioner had not supplied his income certificate as well as domicile certificate and residential address proof document, the authority withheld the allotment letter in favor of the petitioner's husband. The petitioner's husband thereafter furnished the documents and sought for processing the allotment of the site. It is at that stage that the respondent informed the petitioner that since the petitioner's husband had already purchased a site measuring 6x9 meters in Arthavati layout, ಇದು ಎಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು? Purchased a residential building in corporation number 11/2, situated at 8B Cross, Vasant Nagar, 44th division of the corporation of the city of Bangalore. Measuring 306 square feet. The petitioner is not entitled to allotment of the site, and as such, his name is deleted from the list of eligible candidates. It is agreed by the same that the petitioner is before this court seeking for the opposite relief. Learned counsel for the petitioner, by referring to Rule 10(3) of the BDA allotment of site rules 1984, would contain that the embargo which has been imposed under the said rule is only, would come into play only when the site or a house allotted by the Bangalore Development Authority or a cooperative society registered in Karnataka Cooperative Societies Act 1959 or any other authority within the Bangalore metropolitan area. Since the petitioner has not been allotted any site by the BTA, but the petitioner's husband has not been allotted a site as aforesaid, but the petitioner husband has of his own purchased the site in Vasant Nagar out of his own earnings from a third party by way of a private sale, the embargo would not be applicable. And as such, the petitioner's name could not have been deleted from the list of eligible candidates. And consequently, the endorsement issued is bad in law, and the allotment made in favor of the petitioner's husband ought to continue. And upon the expiry of the petitioner's husband, the petitioner ought to be, the sale deed ought to be executed in favor of the petitioner. Per contrast, Shri Basraj Learned Counsel, appearing for the respondent, would contend that the said embargo is not only when the allotment is made by BDA or other society, but when the applicant owns a site or a house. And in the present case, the petitioner husband admittedly owning a site in Vasant Nagar, the petitioner's husband lost its eligibility. And as such, in terms of sub-rule 3 of rule 10, no site could be allotted to the petitioner. Third, so and so. This short question that arises for consideration in the present matter is as to whether the embargo under sub-rule 3 of rule 10 would apply only if there is allotment of site by the BDA or a cooperative society or any other authority within the Bangalore metropolitan area, or would the embargo apply even if a site has been purchased by the applicant, like the petitioner or the petitioner's husband, from and out of their own funds from a private entity or a private person. Correct. Sub-rule 3 of rule 10 has been reproduced way and above. A reading of the said provision indicates that there are several disjunctive segments of the said rule. The rule begins with, inverted commas, no person who or any dependent member of whose family, inverted commas close, followed by, inverted commas, owns a site, inverted commas close, or, inverted commas, a house, inverted commas close, or, inverted commas, has been allotted a site or a house by BDA, ... inverted commas close. Thus, the embargo is not only on a person, but goes on to any dependent member of the family. The embargo arises when such a person or a dependent member of the family owns a site or a house. It is only a further clarification as regards allotment of a site or a house by the BDA, etc. Thus, whether a person owns a site or a house or allotted a site, in all three situations, the embargo as regards eligibility under sub-rule 3 of rule 10 would come into play, disentitling the applicant from consideration of allotment of any site under any scheme quoted by the BDA. In view thereof, there being a clear and categorical admission on part of the petitioner that the petitioner's husband owned a site in Vasant Nagar, having purchased the same would amount to the petitioner who is a dependent of her husband owning a site within the jurisdiction of the BDA, therefore disentitling the petitioner and or her husband from consideration, from being considered for allotment of a site under any scheme of the BDA. Hence, I answer point number 1 as under. In view of this above, I pass the following order. The petition not making any grounds, the petition stands dismissed. Who is appearing for responding now? You will respond to that. If B. Vachan has entered appearance for respond number 1, reference made in the past title that he appears for respond number 2 is directed to be deleted. Place the matter before a bench of which SGRJ is not a party. He did not notice who second respondent was last time. He only said builder last time. R11. R6 to 10. When I give R6 to 10? Pursuant to the order dated 14/6/2022, Registrar Judicial has placed a report. The said report is accepted. The Registrar Judicial is directed to issue necessary instructions to all concerned to verify the payment of process fee from all options which are available in CIS and take necessary action immediately on payment of the process fee. Or in the alternative, direct the person receiving the process fee to make a particular entry in a particular option and not in different options. The report is accepted. Notice to respond number 6, 8, and 10 was dispatched on 14/6 on dispatch hour on 13/6/2022. Seventh. Mr. Nityananda, 7th respondent made. 6th respondent, you accept notice? Is wound up on Kaidara. Shri Nityananda Lalmeji accepts notice for respondent number 6. 8 and 10. Shri Abhinay Vaiti, Learned Counsel, submits that he has filed his Vakalatnama for respondent number 11, registry to verify and print his name as such. 8 and 10, Mr. Abhinay. In friends and directors, co-directors. Not directors. Where is we down? They have been allotted to site now. Each stage is one color, Mr. In Salpadina. Next stage, one step, baby steps. Putting up construction there, you don't know. The same way, new bandit there late on all these things. We should have moved it also. Notice to respond number 8 and 10 has been dispatched on 13/6. Awaiting service. Relist on 28-6, registry to put up postal track record. Oh, already. So, door lock and the notice to respond number 8 has been written with the endorsement door lock, and notice to respond number 10 has been written with the endorsement insufficient address. That counsel for the petitioner undertakes to furnish process fee insofar as respond number 8 as also the correct address, current and correct address of respond number 10. If the process fee and the correct address is furnished, registry is directed to issue emergent notice to respond number 8 and 10, returnable by 12/7, released on 12/7. Correction. So you want to withdraw what?
Indicating that there are some inheritance to the missions made earlier.
ಮತ್ತೆ ಏನ್ರಿ ಇದು there is that KPD matter. When counsel for the petitioner seeks permission to withdraw IA2 of 2022 and file a fresh IA. IA2 of 2022 is dismissed as withdrawn. Released on 24th file ಮಾಡ್ತೀರಾ? 24th ಮಾಡಿದ್ರೆ ನೀವು will have it on 29th. File ಮಾಡ್ತೀರಾ? Mr. Krishna, you are appearing for 2 and 3. Shri K. Krishna has entered appearance for respond number 2 and 3. Registry is directed to delete the name of Mr. Ram Prasad BS and N. Suresh as that appearing for respond number 2. What is this impleading application? KDB. Accepting the reason stated in support of IA2 of 2022, the same is allowed. The executive engineer BDA is brought on record as respond number 5. Shri K. Krishna accepts notice for respond number 5. Amendment eno? Accepting the reason stated in support of IA number 4 of 2022, the same is allowed. Yeah. Objections are key. So ನಿಮ್ಮ ಆರ್ಡರ್ ನ ಕಾಶ್ ಮಾಡಿಬಿಟ್ಟು ಕಳಿಸೋದು. So IA4 may not survive. Accepting the reason stated in support of IA number 4 of 2022, they said application for amendment is allowed. Counsel for the petitioner to carry out necessary amendment and file amended petition. ಅದಾದ್ಮೇಲೆ next order ಮಾಡಿ. ಇಲ್ಲ ಅವ್ರು ಮಾಡೋದೇ. ಯಾವ ಫೈಲ್ ಮಾಡ್ತೀರಾ? Counsel for the petitioner submit that he would file the amended petition in a day's time. Relist on 28/6. Interim order earlier granted is extended till next day. Company petition.
21/7 of this.
The above matter has been wrongly listed today. Relist on 21/7. For whom will you file for R1? R1 and 2. There is no third respondent, but you third respondent and third proceeding. Shri L.K. Manjunath, submit that. Yav file ಮಾಡ್ತೀರಾ? ಒಂದ್ಸತಿ ನಿಮ್ಗೆ ಇನ್ವಿಟೇಷನ್, ಆಮೇಲೆ ವಕಾಲತ್ತು, ಆಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್. L.K. Manjunath, ನೀವ್ ಯಾಕೆ ಮೇಡಮ್ ಅಷ್ಟು ಸ್ಟೇಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀರಾ? The moment an order is passed, that day only you have to serve, not later. Follow him wherever, go there also and serve. ಎಲ್ಲಿದಾರೋ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಸರ್ವ್ ಮಾಡಿ. L.K. Manjunath, learned counsel submit that he would be filing wakalatnama for respond number 1 and 2 in 2 days time. He seeks for and is granted 2 weeks time to file a statement of objection. Objection is written by 8/7, released on 12/7. Oh no, let him see. Other than rule 3. ಕಾಪಿ ಸರ್ ಮಾಡಿದ್ದೀರಾ? ಅದು ಅವ್ರು ನೋಡ್ಬೇಕಲ್ಲ.
Can it be allotted to some other person? It was notified for this person and it is allotted to him. Earlier it was notified for different person, but he was allotted. He did not fulfill the condition. He cancelled.
So you change the purpose.
Change the purpose was CH-21 is already allotted to them.
Will you be ready now only, Mr. Mukliddar, or you want time to see? So, M.V. Charity, learned counsel for respond number 1 and 2 submits that he would be filing the statement of objection during the course of the day after serving copy thereof and the counsel for the petition. And counsel for the petition seeks for and is granted a week's time to go through the same, get ready and make a submission, released on 28/6.
31, kindly direct the office not to show my name, my lord.
T.P. Rajendra Kumar Sunghe has entered appearance for respondent. Registry is direct to delete the name of Sri Narendra Gowda and Sri K.N. Putte as that appearing for the respondents.
Obliging.
Sir, Sharath. Mr. Sunghe. None appears for the petitioner. Objections are also not filed by the respondent. 2 weeks time is granted to the counsel for the respondent to file objection. Objection is accompanied by 8/7, released on 12/7.
I appear for the respondent in one case and petitioner in the other.
Just one moment. Just one moment. First of all, clean man. Sumana Naganand has entered appearance for the petitioner in WP number 47525. Registry is directed to correct her name as SUMANA Naganand and delete the name of Shri P. Anand and K.C. Shantkumar as that appearing for the petitioner. 32.1. Ms. Sumana Naganand has entered appearance for respondent number 4. Registry is direct to delete the name of K.C. Shantkumar and P. Anand as that appearing for respondent number 4. 1, 2, 1, 2, 3, 4, like that. Yes. In the morning, this matter was mentioned and there is opposition. Now you cannot come and say this. You have to get ready and argue the matter. You should have produced it by now. This is a 2016 matter. So another 5 years later, you'll get one more document. I'm not the way, Mr. Counsel. You are the petitioner. Mr. Krishna, you have filed your objection.
It's the fifth round of litigation, my lord.
Fifth?
Yes. All 4 rounds we have won and they have lost. But still, my lord, they persist. Up to Supreme Court, every case.
Fifth round ಅಲ್ಲಿ ready ಇರಬೇಕಪ್ಪ. ಇವಾಗ ಇನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂದ್ರೆ you are the petitioner in 32.1. When it counsel for the petitioner in WP number petitioner 4 to 6 in WP 5201 of 2017. What about 4? You are from Mr. Shivramu's office or? The Bernard counsel for your predecessor, whatever order is there, you are bound by it. Now you can't set up a new case. Counsel for the legal representative deceased P1, P2, and P3 seeks for and is granted 1 week's time finally to produce certain documents that he intends to rely upon. Released on 28/6/2022, it is made clear that no further adjournment would be granted. You are appearing in this matter? You are appearing for the BDA. They wants to produce some document.
Yes.
28.
28. Yes.
Tuesday and BDA matters. 2:30. You are ready, Mr. Nagana?
Yes, yes, my lord, please.
28 to 2:30.
Please, my lord, please.
At 2:30 p.m. Shri B.S. Karthikeyan has entered appearance for respondent. Registry Director brief name of Mrs. M.V. Tanuja is that appearing for the respondent. I wrote that. I had ordered dated 31/5/2022. The registry was directed to delete the name of Shri M.V. Tanuja, but the same has not been done. Registrar Judicial is directed to look into the matter. Why do you need the original file to register the sale? You can, whenever a file is sent from here to the apex court or from the trial court to this court, if an application is filed, there's an order sheet opened and the order could be passed. This is the original file which is required for evidence, Mr. Karthik, and they won't return it to you. It took an order from this court for you to do this. And this matter has been pending for the last 6 years for that reason. So who is to blame for it, Mr. Karthik? Why should a litigant wait for 6 years for this? ಇವಾಗಲೂ ಮಾಡ್ಕೊಡಲ್ಲ ಅಂತೀರಾ ನೀವು? ಯಾವಾಗ ಅದು ಒರಿಜಿನಲ್ ಫೈಲ್ ಬಂದಾವ? We'll keep this pending. You execute it and then let us know. The status report from affidavit or the Deputy Secretary to or the Bangalore Development Authority has been filed, stating that it is in pursuance of the orders of this court, dated 31/5/2022, that he had visited the office of the Lokayukta as also the Lokayukta court and was able to secure a photocopy of the file relevant for this matter. It is rather shocking that the BDA has swung into action only after orders passed by this court. It is required that in any case, in any litigation, where any document is seized by Lokayukta, ACB or other like authority, the BDA apply for and obtain copies of the said file so as to enable BDA to discharge the statutory duties. The counsel for the respondent is directed to bring the above observation to the notice of the Commissioner of the BDA so that necessary applications could be made in all pending matters where files have been seized by any authority, including Lokayukta, ACB, PMLA, ED, or otherwise. The first occasion was 2019, second occasion was after this order. Date and you produce Madira 7/1/19, second is 18/6/2022. Anyway, get all of them so that these don't need to. In another matter also, Lokayukta gave the copies. They will give you copies. You apply. You haven't followed it up. To show this order in all matters. This is for all. Needless to add that if any application is made by the BDA to any such authority, the authority would be bound to issue photocopies, to issue certified copies of the documents so as to enable the work of the BDA to go on. The status report to be filed in relation thereto within 2 weeks from today. ಬೇರೆ ಎಲ್ಲ ಹಾಕಿ ಇಲ್ಲಾಂದ್ರೆ ಒಂದೊಂದರಲ್ಲೂ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. See, for that simple reason, when you have approved a sale in favor of the petitioner, sale deed has not happened for 6 years. You don't know, but we can guess. Get all the papers in all files it will enable you to go on with the matter. So ಯಾವಾಗ ಬರ್ಬೋದು? We'll give it 2 weeks time. We list on 5/7. Our report on over 5/7. ಅದಕ್ಕೆ next 12/7. We list on 12/7. Mr. Butcher.
I appear for respondent, Your Lordship. Respondent 20. The petition will not survive.
The petition will not survive, Mr. Kiran?
Yes, Your Lordship, because the challenge at 24+2, the same is not applicable to BDA.
BDA.
Order of
27 ಇದೆಯಲ್ಲಪ್ಪ. Last time we observed, you made that submission.
Yes,
we observed that there are challenges to section and section 27 also. You have to verify and make your submissions. It's not restricted to 24(2).
Nodilva. Prayer will be mentioned, Your Lordship. They are not mentioned in the prayer 27, Your Lordship.
Prayer is only one, this one. We'll see the grounds. And we have made a note of this submission on the last order sheet. We clearly stated that we submit that no award has been passed, no compensation. Therefore, the justice would have to be held to have been lapsed in terms of section 27 of the BDA Act. Faced with the situation, the current civil learner counsel the response seeks for and is granted 2 weeks time to verify and make a submission. Matte ade submission ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Regard to award has been passed, Your Lordship.
So place it on record.
Your Lordship, yesterday evening I got the award copy and everything, Your Lordship.
Shri CV Kiran seeks for and is granted 1 week's time, Saka.
Much obliged, Your Lordship.
1 week's time, we list on 28/6.
Much obliged.
Interim order earlier granted is extended. And AGA submit that I passed last time. Respond number 3 is the last time. Article 14 violation ಆಗುತ್ತೆ. Private part. It's a separate category and classification. We'll direct the law officer of BDA to pay every time if you don't get instruction. Then AGA submit that he has received his paravise comments yesterday and he seeks for a week's time to file his to file his statement of objection. Objections, if any, to be filed on or before 27/6, released on 29/6. Objections, if any, to be filed on or before 30th June, released on 4th July. Yes, Mr. Sachin, ready? ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ? ಡಿಕ್ಟೇಟ್ ಮಾಡಿ 1:30 ಆಯ್ತು. You come back at 2:30. Yes.
Yesterday I have filed a
ಯಾರಿಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? ಏನ್ ನಿಮ್ಮ ಹೆಸರೇನು? Shri D.V. Ramurthy has submits that he has filed wakalatnama for the petitioner. He seeks for and is granted a week's time to get ready and address his arguments. Registry is directed to print his name, to verify and print his name as that appearing for the petitioner. Yard matter na? 37, 37.2, 37.3 and 37.4. 37.1 ಅಲ್ಲಿ ನೀವಿದ್ದೀರಾ? What about objections, Mr. Girisha? It's filed. Vacating step ಬಿಡಿ, ಅದು ಆಮೇಲೆ ತಗೋಣ, ಒಟ್ಟಿಗೆ ತಗೋಣ. ಇದೇನಿದು ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಿದು? ಒಂದು ನಿಮಿಷ. IA 2 of 2024 ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಿದೆ? 37.3. ಹಲೋ ಮಾಡೋಣ. 37.3 accepting the reasons stated in support of IA 2 of 2020. The amendment sought for is allowed. Counsel for the petitioner to carry out necessary amendment and file amended petition. Additional objections, if any, to be filed on or before 1/7/2022. Released on 5/7/2022. Interim order earlier granted is extended to next week. 57. Who is appearing for the petition now? Mr. Gautam Bharadwaj is appearing. Shri Narendra Gowda has entered appearance for respond number 2. Registry direct delete the name of MB Tanuja as that appearing for respond number 2. Counsel for the petitioner seeks for and is granted a week's time. Released on 28/6. There are some orders to be passed. Wait. 53. 53. Shri Lakshmi Rao submit that he is entering appearance for respondent. Registry is directed to verify and print his name as that appearing for respondent and delete the name of MD Tanuja as that appearing for respondent. Objection hakidara? Shri Lakshmi Rao seeks for and is granted 2 weeks time to file a statement of objection. Statement of objections to be filed on or before 8/7, released on 12/7.
ಈ 58 ನನಗೆ ಕಾಪಿ ಶುರು ಮಾಡಬೇಕು ಅಂತ ಆದೇಶ ಆದ್ರೂ ಮಾಡಿಲ್ಲ.
58 ಅರ್ಜನ್ ಆಗಿದೆ ಮಿಸ್ಟರ್ ಪುಟ್ಟೇಗೌಡ. 5th July.
Court officer? Court officer? Court officer? Court officer? Court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಇದು ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಅಥವಾ 230 ಲಿಸ್ಟ್ ತಗೊಳ್ತಾರ ಸಾಹೇಬ್ರು?
ಸರ್ ಒಂದೇ ಒಂದು ಪಾಸ್ ಓವರ್ ಇದೆ, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
54 ಏನಾಯ್ತು ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 54.
54 5 7 ಸರ್ ನೆಕ್ಸ್ಟ್ ಡೇಟು.
ಥ್ಯಾಂಕ್ ಯು.
54 ಇದೆ ಸರ್ ಪುಟ್ಟೇಗೌಡ್ರು.
ಹಾ ಮೇಡಮ್.
54 ಇದೆ, 58 57.
ಓಕೆ ಓಕೆ ಮೇಡಮ್.
ಸ್ವಲ್ಪ ನಿಮ್ ನೆಟ್ವರ್ಕ್ ಇದು
ಇಲ್ಲ ನೆಟ್ವರ್ಕ್ ಸರಿ ಇದೆ, ನಾನ್ ಮಾತಾಡೋದು ಸರಿ ಇಲ್ಲ. ನನಗೆ ಸ್ವಲ್ಪ ನ್ಯೂರೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಹಾಗಾಗಿ ನಾನು ಸ್ವಲ್ಪ ಸ್ಲೋ ಮಾತಾಡೋದು. ಸಾಹೇಬ್ರಿಗೆ ಗೊತ್ತದು.
ಸರಿ ಸರ್, ಬೇಗ ರಿಕವರಿ ಆಗಿ.
ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 39 ಮೇಡಮ್.
39 ಇದೆ ಸರ್.
ಇದೆಯಾ? ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಜನ ಖಾಲಿ ಇತ್ತಂತೆ ಬೊಮ್ಮಘಟ್ಟದಲ್ಲಿ 2 ಬಸ್ ಮಾಡವ್ರೆ ಬಸ್ ಜನ ಇಲ್ದರೆ
Court officer. Court officer. Court officer.
Court officer ಇದೀರಾ? Hello. 230 ಮೀಟರ್ ತಗೋತಾರಾ?
Serial number 15.
That was prior to the demand. You have to issue notice. So let us see. Let me know. The above matter has been. Sorry. The above matter has been remanded by the apex court for fresh consideration. The AGA accepted notice for respondent number 1. Shri G. Lakshmi Rao has accepted notice for respondent number 2 to 9. Shri N.R. Jagdishwara has accepted notice for respondent number 10 and 11. 12, what has happened? 12 is dispensed with. Void order dated 23/9/2015. Notice to respond number 12, 19 to 22. Notice to respond number 12 has already been dispensed with by order dated 23/9/2015. What about 13?
13 is dead melons and they filed a memo. 14 is LR of 14.
All the councils submit that respondent number 13 has expired and respondent number 14 is the legal representative of respondent number 13. When was the memo filed, Mr. Kanindra?
After the remand,
Any order passed? 24/2022. Hence, by order dated 20th April 2022, the 14th respondent has been treated as the legal representative of the 13th respondent. Ms. Vaishali Hegde has entered appearance for respondent number 14. What about 15, 16, 17?
15 and 16 is the one where service has to be effective. 17 has died.
15 and 16, huh?
17 has died.
Shri Kiran Kumar DK had undertaken to appear for respondent number 15 and 16 prior to the remand. However, no wakalat has been filed by him in respect of the said respondents. Hence, notice would have to be issued to respondent number 15 and 16. 17 is dead. Respondent number 17 having expired, notice had been issued. When was notice issued? When did he expire? Prior to the remand or after the remand?
He died on 12/3/2016 during the pendency. During the pendency,
So after remand, we need to issue.
actually, after the writ appeal was the writ petition was appear. So,
Respondent number 17 had expired when the writ petition was pending before this court. Hence, on an application being filed, notice was ordered on his legal representatives. Though they are served, none has entered appearance for respondent number 17. None has entered appearance for respondent number 17, 1, 2, and 3. Hence, service has been held sufficient. Ms. Vaishali Hegde has entered appearance for respondent number 18. Notice to respondent number 19 to 22 has been dispensed with by order dated 23/9/2015. In view of the above, all respondents are accounted for except for respondent number 15 and 16. Hence, issue notice to respondent number 15 and 16, returnable by emergent notice to 15 and 16, returnable by, what is the classification? 19/7/2022, we list on 19/7. Counsel for the petition is also permitted to take out hand summons on the said respondent number 15 and 16.
meanwhile, the interview during the pendency of the portion of the property was acquired. In spite of the interim order, there is a compensation from Metro for about 16 crores. The Honorable Division Bench had directed them to keep that entire compensation amount in a revenue and not to spend that. That has been continued with the pendency of the restoration under the order of the defendant. The details letter furnished because we don't have any details after.
Counsel for the petitioner is directed to furnish details as regards the demand, as regards the deposit made by the petitioner in terms of the orders of the division bench, as regards the compensation amount received by the petitioners in a fixed deposit by the next day. Yes. What does the state have to say? Nityananda, what is the state's contention? The director must be V. Krishna too. ಅಲ್ಲಿ ಬರೋವರೆಗೂ ಇಲ್ಲಿ ಏನು ಶುರು ಮಾಡಂಗೆ ಇಲ್ಲ, ಅವರೇ ಇಂಪಾರ್ಟೆಂಟ್. ಇಲ್ಲೇ ಇದ್ದಾರೆ, AG's ಆಫೀಸಲ್ಲಿ ಇದ್ದಾರೆ, ಅಲ್ಲಿಂದ ಬರೋದು ಲೇಟ್ ಆಗುತ್ತೆ. We'll pass over and see. We'll go on with the list. We'll take it up when she comes. Pass over. Amended distribution ಜೊತೆ ಏನು annexes produce ಮಾಡಿಲ್ಲ ಅನ್ಸುತ್ತೆ. Yes. Page number?
Next year, page number 10.
Yes.
11 purchase the property. One is Parimana. And that's the schedule is at page 24. Property building number 10 in chapter number 20. Around 6,000 square.
Yes.
Subsequently, connection page 26. Rather was issued by the
Mentioning yesterday in the letter. 60 feet on the southern side, 64 on the 62 by 110. Yes.
But the other certificate is a connection page 26. PID number is important 55 107 17
Yes.
Subsequently, after extract was given by annexure to page 27, and I sought for permission to put up construction. License was also granted to put up construction. That is at annexure D page 28.
Yes.
Then when I was putting up
Who
construction.
gave you the land sanction?
Land sanction was made by the DBN.
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 Yes.
While annexure K page 35. The order included in the presentation going to be fast. Stating that the petitioner had encroached upon the clear property. And he was directed to stop construction immediately.
Yes.
And to remove the construction already. This sort of order is challenged in the presentation.
321 order.
They say that I have encroached upon the BDA property and I'm constructing in the BDA.
So reply to it.
We have replied by annexure L page 26.
We'll consider it.
Then subsequently, what has happened is there are two reports by the PDA itself, BMTF division. Before consideration of the reply, I came to this one report. There was an implement. Then there is a report. They themselves called for, they issued notice. They called for all the documents. I have furnished documents. They say that this property is not a building. Petitioner has not impressed upon me.
Where are they said that?
Annexure M, page 38. This is a document after filing of the 94/2018.
ಅವರಿಗೆ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರಿಗೆ ಯಾರು ಬರ್ದಿರೋದು ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ BMTF.
Kindly turn to page 39.
Yes.
The last paragraph. Suddenly, Guru and Pierre Uchani and GM Guru Dakshinamurti for the part of PA of Karnataka, ಮತ್ತು ನಕ್ಷೆಯಲ್ಲಿ ಕತ್ತಿಗುಪ್ಪೆ ಗ್ರಾಮದ ಸಂಕಲನ 17 ಭವಾನಿ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘದ ಹಿರಿಯ ಹಂಚಿಕೆ ಮಾಡಿ ಅದರ ಹಂಚಿಕೆಯಲ್ಲಿ ಜಾಗದಲ್ಲಿ ಈಗಾಗಲೇ ಕಟ್ಟಡಗಳನ್ನು ನಿರ್ಮಾಣ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯ ವಹಿಸಿಕೊಡಲಾಗಿತ್ತು ಹಾಗೂ ಕಟ್ಟಡದ ಮಾಲೀಕರಿಗೆ ನೀಡಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಶ್ರೀ ಮುನಿರಾಜರ್ ಅವರು 2016ರಲ್ಲಿ ಕಂದಾಯ ಇಲಾಖೆಯಿಂದ ಸುತ್ತಿನ ಗುರುತಿನ ಸಂಖ್ಯೆ ಗೇಟ್ ನಂಬರ್ ಸ್ಯಾಂಕ್ಷನ್ ಇರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕಚೇರಿ ನಂಬರ್ ತಡೆಯಾಗಿದೆ ಎಂದು ದಿನಾಂಕ ನೀಡಿರುತ್ತದೆ ಮತ್ತು ಭವಾನಿ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘದ ನಿರ್ಮಿಸಿರುವ ಬಡಾವಣೆಯಲ್ಲಿ ಅನುಮೋದಿತ ಲೇಔಟ್ ನಕ್ಷೆಯಲ್ಲಿ ಸದರಿ ಸ್ವತ್ತು ಸೇರಿರುವುದು ಕಂಡುಬರುತ್ತಿದೆ. ಮೀಡಿಯಾದಿಂದ ಹಂಚಿಕೆಯಾಗಿರುವ ಜಾಗವಾಗಿದ್ದು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ದೂರು ಅರ್ಜಿಯಲ್ಲಿ
Who is the police inspector to give this kind of a report, Mr. Shah? You want the police inspector to decide the.
It is not at my instance.
Yes.
What may kindly see?
As the BDA said that there is no encroachment. You just mentioned that BDA has given an endorsement.
Annexure M, page 41. Based on that, in fact, it was the BDA who had addressed a letter to the police inspector of BMTF. Based on this letter, this is the report at Annexure M dated 19/4/2000. BDA sought for the report.
And what is the effect of this letter? They are only saying it's been handed over to the BMT.
So they say that this land is not being encroached.
Where do they say in Annexure N that it's not been encroached?
ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Page number 39.
39 ಅಲ್ಲ, 39 police inspector. We are not concerned with police inspector.
They sought for information from the police.
They sought, but now can we recognize the police inspector to decide the title? If we decide, if we hold like that, ಮುಗಿತ್ ಕತೆ. ಎಲ್ಲ ಅಲ್ಲೇ ಡಿಸೈಡ್ ಆಗುತ್ತೆ.
The note sheet maintained by the BDA member at Annexure P.
Now you have given a reply, let them decide on it. You can't go by the police. By when will you decide, Mr. Sachin? Expedited a time. Petitioner is before this court seeking for the following leaves. Though the petitioner has termed Annexure K as an order, the peril of the same indicates that it is a notice requiring information from the petitioner and as such a show cause notice. The petitioner has replied to Annexure K, filed Annexure L dated 6/12/2016. Shri B.S. Sachin, learned counsel for the respondent, submit that the respondent would consider the said reply and pass necessary orders within
4 weeks.
Months or within 4 weeks from today. Placing the submission. ನಾಳೆ ಬೆಳಗ್ಗೆ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ. ಅಲ್ಲಿಂದ ಶುರು. ನೀವು when you want to do it, one notice ಕೊಟ್ಟು next day ಹೋಗ್ತೀರಾ demolition. ಅವಾಗ ಅರ್ಜೆನ್ಸಿ ಹೆಂಗ್ ಬರುತ್ತೆ? ಇವಾಗ್ಲೂ ಮಾಡ್ಬೇಕು. ಎಲ್ಲ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಒಂದು ಮಾಡಿ. Within 4 weeks from today, this submission is placed on record. Needless to say that until an order is passed thereon, the respondent shall not take any coercive steps against the petitioner. The petitioner further needless to say that the petitioner shall also not carry out any further construction than that carried out as on today. As on today only we can order such. And you take photographs from today and put it in the file. If there's anything that they do, you can bring it to notice. Yes, Mr. Speaker, what is this? Yes. So what do you want to do?
No building or put up. It is actually kept as a vacant land, and essentially the residents can affect that. Therefore, the rental which is imposed, it runs to some 2 crores initially and then 40 lakhs per year. Even the association members are finding it a very.
Once it is, then everybody will have entry.
On that point, my lord, I will complete proceed, my lord, that the property under consideration is slightly in a different category than a general public property which is to be allotted under the city community.
It can't be a different category. Show us where it is.
Very briefly state the facts, the sequence of events, so that the property management is part of a development. The initial development plan was approved in the year 2005. At that time, the regulations required that the civic community sites and the park and open areas would be relinquished to the BDA. The condition imposed in the plan. The first modification was done after 2007, and the new CDP was notified. And under the new CDP, the regulation 7.1 and 2 did away with that requirement of relinquishment of the civic community areas and reduced it from 10% to 5%.
Yes.
But that change was not imposed when this modification of sanction was given. So the relinquishment of 10%.
It can't be, your plan sanction is 2005.
Yes, ma'am.
So you'll be down by that.
2005. It was modified in 2009.
No, in 2005, when you are required to relinquish, you are required to relinquish. Modification, you cannot claim benefit of.
Why not? The condition imposed for sanction was relinquishment. I complied with it.
Yes.
Subsequently, the regulations changed. But when I modified it, there was no change.
So once it is relinquished, the deed is completed. Now you cannot go back, is what we are saying.
No, my lord. I'm just stating that because in one of the decisions, the observation made is that there was no modification by restoring back the excess civic community area and the change of this thing. Therefore, that contention cannot be considered as an observation. It is in that context that I'm just highlighting that.
Okay.
Then, my lords, in 2012, the owners association was formed of these residents.
Yes.
And in 2014, the developers submitted requisition for allotment of the civic community areas. Pursuant to that, in 2016, the endorsement which are included was issued, which are connections. G, my lords.
Yes.
Whereby the civic community sites, 3 sites were proposed to be allotted on a lease rental, which is specified there at the rate of 2962 per square meter. Now, subsequent to this, because of the regulation 7.1 and 7.2 of the CDP 2007, the owners association submitted a representation saying that this cannot be leased out to the developers. It has to be handed over to the owners association in accordance with the regulations. And with the consent of the developer, this petition is filed seeking for that remedy. That representation has not been acted upon. Therefore, essentially, the first relief sought for finance is that the lease rental, the proposed lease in favor of the developer should be cancelled, and the representation should be considered for handing it over to the owners association.
That is the second prayer.
Yes, sir.
That will come into consideration only if the first prayer you succeed.
Yes, sir. So, insofar as the lease is concerned, my lord, so in this background, my lord, there are several decisions of the Honorable Court,
yes,
in which I had filed this list of citations already, my lord. It's available in the file.
Yeah. Yes.
There are 4 decisions referred to. There is one more decision I handed over separately, my lord, which
Yes.
takes a different line from this.
Mhm.
Now, the first decision, my lord, is decision dated 13th July 2011, where also first the plan was sanctioned before 2007 regulations. Relinquishment deed was executed in 2005.
Yes.
Here again, my lords, at paragraph 9 onwards, the court holds that this is not a civic amenity insofar as the rules of 1989 are concerned, and 7.1 and 7.2 will apply.
Yes.
May I read that, my lords? Paragraph 9, the judgment from page 8 onwards.
Yes.
Paragraph 9. Having heard the counsel for the petitioner or perusal of the material on record, it is noted that the petitioner, who is a developer, has developed a group housing residential project called Golden House. It's a said group housing project. The 5 flats have been constructed. Cartographers have formed the apartment owner association, which is a registered body. State government has approved by order dated 25/6/2007 the revised master plan. The object of the said master plan is to have a planned growth of the city. There are zonal regulations and local planning area that is Bangalore divided into points and planning districts. In the revised master plan, authority is defined to be PD. Chapter 7 of the revised master plan deals with the residential development plans and non-residential development plans. 7.1 reads as follows. So 7.1 says 10% of the land reserved for park and open space will be relinquished. 7.2 says minimum of 5% of total plot area shall be provided for civic amenity, and the owner or developer shall develop such civic amenity, which finally shall be handed over to the local residents association for maintenance. The mode of such handing over shall be decided by the authority. FAR so and so parking requirements roads. On a reading of the said regulation, it becomes clear that 10% of the land in residential land has to be reserved for park and open spaces, and 5% of the total land area has to be reserved for civic amenity purpose. Insofar as 10% of the land reserved for park and open space is concerned, same has to be relinquished by the developer to the authority PD, and the same can be permitted to be maintained by the local residents association. Insofar as 5% of the area provided for civic amenity is concerned, the developer has to develop the civic amenity, and thereafter same has to be handed over to local residents association for maintenance. Mode of such handing over has to be decided by authority. Therefore, representations have been made in that regard both by the developer as well as the association to permit 10% of park and open spaces, which have been relinquished to BDA for permission to maintain the same by association, and further a request has also been made for development of 5% civic amenity areas, so that the same could be handed over to the local residents association for maintenance. By considering the said representations, the BDA has applied the rules of 1989, which in my view are not applicable. I will regard to the fact that regulations, and particularly regulation 7.1, are clearly specific. And
there's no dispute about this issue, Mr. The issue is not whether it can be given to you or not. The issue is you are asking for waiver of the lease rentals because there's a lease deed executed. So how does the handover is under a lease only for a period of 30 years or whatever with a renewal clause. The question is, what is the amount payable on it in your case? Granting it to you is not in question. I think Mr. Sachin will not dispute that.
Yes. They made a request for an allotment that we have made.
We don't expect him to dispute that, and we have so many judgments. Only issue which is different in your matter is the rentals. Now, if you want a waiver, then it is a gratis, it's a grant.
My lord, that is where I'm trying to point out the decision say that this cannot be a subject matter of lease by the authority and whereby rentals can be charged. It has to.
Where does it say that? Where does it say lease rentals cannot be charged?
Paragraph 30. Bear with me. Previous paragraph which I was reading, I just read that one paragraph and go to 30.
It just shows that line, that's all. The others is enough. There must be some pen judgments on that.
The paragraph 30, chapter 7 of the revised master plan deals with regulations for residential development plans and non-residential development plans. 7.1 deals with residential development plan, which is under consideration. Regulation 7 deals with the manner in which areas reserved for park and open space which are relinquished can be maintained. As far as civic community sites are concerned, Regulation 7.2 provides for development of such site by developer and maintenance. Thus, open space and park areas of the civic community sites may be relinquished by the developer or the private layout through the authority. Nevertheless, the regulation chapter 7 prescribes is only with regard to maintenance of said area. The said regulations do not deal with disposal of such sites. Even in the absence of disposal of said area by the authority, the maintenance of the said civic community can be handed over to the registered local residents association. It is only when the civic community site is allotted to specific categories of persons that the BDA regulation 89 will apply. The said allotment would be having regard to various criteria aspected in 7, 4, and 10. Therefore, when there is no allotment of civic community site, but only the maintenance of the same has to be considered, Regulation 7 of the Master Plan 2015 will apply, not rules of 89. It is only when civic community site is to be disposed of on the basis of a lease to be executed by authority, 89 rules apply.
So that's how they say it's not a lease, it's only handing over for maintenance.
Yes, my lord. And this, my lords, again is followed in the next decision, which is the same petitioner. Subsequently, again, lease was imposed. There, my lords, in the next decision at paragraph 15, my lords. That is at page 14 of the judgment. Paragraph 15. In view of the relinquishment deed dated 22/11/2005, executed by the petitioner and the BDA having become the absolute owner of civic community areas, should permit the petitioner to develop the civic community site in question in accordance with law for handing over the same to both respondent for maintenance. Yes. Petitioner is not entitled to make any profit out of so and so much.
Yes.
Then, my lords, in the next decision, that is 2013 Karnataka Law Journal, Para 6, my lords, at the page 240 of the judgment.
Yes.
In the instant case, the land of the petitioner of the development plan indicating the area earmarked for civic community sites were duly approved. The petitioners have relinquished the said civic community sites in favor of BDA. The said civic community sites were to be developed at the cost of the petitioners for the purpose indicated in the sanction plan. There is no dispute that the petitioners seek to develop the specified amenities for the benefit of the local residents, who apparently would have paid the price for such facility being provided as a common facility for all the residents. There is hence no consideration flowing from BDA in seeking to impose conditions of payment of lease rentals, a deposit or structure. Property taxes in any event would be payable in respect to the structures which would adequately reimburse the BDA or such other local authority which provides a general facilities such as water supply, sewerage connections, or provided the same are not alternatively provided for in-house. The BDA not being able to resist the imposition of the above rentals only on the basis of circumstance and the law requires the civic community site to be relinquished in favor of the authority as a precondition to development of land, and that the same stands listed in it on a day is unreasonable and arbitrary. The obvious requirement that civic communities and parks as well as open spaces are pertinent to any such development of land, as in the present case of land, being relinquished in favor of BDA, is to ensure that the same are compulsorily maintained as such and that the developer does not dispose of the same for private profit. Therefore, the authority being given the discretion to decide the mode of transfer of civic community in favor of local residents association after the development of the same only implies that the ultimate transfer is based on terms as to the manner in which the civic community should be maintained and the terms and conditions on which any civic community will be thrown open to the general public if there is a possibility or such other safeguard being worked.
This is exactly what we are saying.
My lords, here, my lords, in that context, my lords, very clear that it can be thrown out to the public. Regarding that, my lords, my submission is the property being handed over to the BDA is for the specific purpose of civic amenity for the local residents in which the project is developed. And it is even in the judgment it is recorded well, it is they who bear the cost of development of the amenity. Now the whether BDA once it acquires this land becomes an owner of land which otherwise it has acquired, or is placed in a position as a trustee to hold the property only for this purpose.
Now, if you are a lessee, you can have restriction on people coming. If you are a grantee, like what you want, you can't have restriction.
That, my lords, again, I reiterate this sentence, my lord, in the judgment. Fifth and sixth line, my lords. Therefore, the authority being given the discretion to decide the mode of transfer of civic amenity in favor of the local residents association.
We are not on the mode also, Mr. Sridhar. We are on, if you are going to say, if you are lessee, you have control over the property as a lessee. If you are not a lessee and you are being given only maintenance, then you can't prevent anybody. If I want to come there, you have to allow me.
My lord, that is why I am stressing on this one sentence.
If Mr. Manish wants to come there, you have to allow Mr. Manish.
If it
He
is
is
a possibility,
getting ready to come there.
if there is a possibility, my lord, that is the one line I want to stress.
There you have to make possibility.
If terms are to be imposed to permit them to
If
be.
Mr. Manish comes to your gate and says, I want to get in, you cannot stop him from getting in.
My lord, it is being maintained as a playground. If
He wants to come and play. If he wants to come and play cricket, you have to allow him to play cricket.
As a guest, definitely, my lord. But
Whatever.
If
he says, I want to come at 6 o'clock in the morning, you have to allow him. If he comes at 6 o'clock in the evening, you have to allow him.
subject to conditions which may be imposed, my lord. It cannot be that after bearing the entire cost, I am put on the same terms as somebody who has absolutely no connection with this land.
You have no ownership over the land or no title over the land. It's a land belonging to the BGA. If you take it on lease and if you are going to make payment of the lease rental, then there could be some conditions that you could impose. But if you want it gratis, then it's a public property as a civic community relinquished in favor of the BDA. You will have to allow third party. That is the only thing that we are telling you.
My lord, that is where my lord, my submission is only that much, my lord. One is it is not gratis because I am the one who has borne the cost for development of that amenity.
If you are not willing for that condition, then prayer A will be rejected.
Prayer A, my lord, because lease cannot be granted. That is what all the decisions say, that 1989 rules will not apply because this is not the BDA layout and civic amenity only in the context of BDA layout is applicable.
That's why we asked you to check with your clients and get back.
My lord, it is a playground, my lord, sir. Cricket field. They are insisting on lease rental of 2 crores, my lord. At least let them consider whether that can be.
That you give a representation to reduce.
That is a
That they can
owner
consider.
association has given, my lord. That the lease rental let it not be
Really,
done. My representation, my lord, that is precisely what I have also submitted.
On what basis have you valued this amount, Mr. Sachin? No discretion. What is the basis?
My lord, sir, they themselves when I made a request, please allot me. I am ready to bear the cost.
What you have valued it at 2 crores. What is the basis of that valuation? Resolution, but a basis of calculation.
Yes, calculation.
Your resolution 2 crores and 20 crores. Justify that amount.
Yes, we passed a resolution, page number 14, page number 5 of my statement of objection.
Adhikara Sabhage Tifni R1.
what is the basis? My lord, I draw my lord's attention to paragraph number 5 of the statement of objection. Additional statement of objection.
Additional statement.
What is the basis for fixing the price? It has no mention, and it is not a space also.
He is asked for prayer 2
Yes,
for
prayer-
waiver of it.
Prayer number
What
2.
is this case?
Prayer number 2 in the rectification is that to consider the representation dated 8/8/2016 to facilitate the handover of the parks and open space for in favor of the
What is the basis of the calculation, Mr. Sachin?
calculation has not made a mention in my objection.
ಅಷ್ಟೇ ಹೇಳಿ ಮಾಡಿಲ್ಲ ಅಂತ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
Because it was not a part of the pleading here.
Don't beat around the bush. If you are not calculating, you calculate and let us know.
Yes.
On what basis you have done this calculation? There is no discretion with
We have
BDA.
fixed the price based on the measurement.
Please don't make that submission of absolute discretion of BDA.
Yes. My lord,
But again, you have valued it as lease.
yes.
Now, this court has held that lease cannot be there.
No, because because what had happened was that the allotment of CSI has to be made as per the rules mentioned under the
Mr.
allotment
Sachin,
of civic community sites.
This court has categorically held
Yes.
that 89 rules are not applicable.
Yes.
You cannot lease it. You can give it for their maintenance.
Yes.
But when you are doing so, you can fix some things. So when you are fixing it, on what basis you are fixing it, is what is there. You cannot fix a lease and annuity.
I'm making submissions.
Hmm.
It is a request made by the petitioner to allot the site, to allot the land, subject he is ready to pay the cost. That is his representation.
Here are the judgments that Mr. Sridhar relied upon. Take the first judgment and come to para 13.
I have read it.
Para 13 ondsati ಓದ್ಕೊಳ್ಳಿ. ಏನನ್ನತ್ತೆ?
But this is a different fact. The reason is, my lord, now this is a group housing project. This is a group housing project. The group housing project was sanctioned subject to condition that he has to release the civic community site immediately.
ಎಲ್ಲಾದು ಕಂಡೀಷನ್ ಅದೇ ಇರತ್ತಪ್ಪ. ಇಲ್ಲೂ ಅದೇ ಕಂಡೀಷನ್.
That they have done it.
Even in this, the same condition.
Now, my lord, for that, revised master plan of 2000.
Regulation 7.1 and Regulation 7.1 and 7.2.
That had come subsequently. Yes, no, my lord, probably petition has not entered to this.
Now, the time at which you are giving it to them,
Yes.
is the RMP in force?
No.
When did RMP come into force?
My lord, RMP 1995 was in force.
When are you now giving? When are you giving it to them?
Please, my lord.
When are you giving the property to the petitioner?
My lord, the release date was executed. It was in force. It was the development plan was approved on 19/12/2005.
Mr. Sachin, please understand the question.
Please.
When are you giving it to the petitioner for maintenance? What date?
We are not giving for it for maintenance. We are giving.
When are you giving it to them? Under whatever head? Which date?
Yes.
Inna kottilla tane?
Inna kottilla.
So the law which is applicable now is what?
Maintenance of KD. Our KD our representation. Then allotment.
ಹೌದಪ್ಪ, ಇಲ್ಲೂ ಅದೇ ಇದ್ದಿದ್ದು. And what did this court say? You are arguing against the decision of the court. This court has said that once the RMP comes into force, you can't lease it. In number of decisions, there must be some 20 decisions on it. In spite of it, if BDA wants to make this submission, then we find the submission to be completely nullified. We want to argue against the decisions of this court. Para 13 ಓದಿ ಅಂದ್ರೇನು ಓದಲ್ಲ ಅಂತೀರ ನೀವು ಓದ್ ನೋಡಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ. Can you take a stand other than what this court has said? You do it.
Here in case they have released the land.
In all matters, it is released. Before the plan sanction, Tappa, you ask for release. Before you give the building sanction, development plan, relinquishment. Before the building plan is sanctioned, you have to have a relinquishment deed. There is no doubt about it. That is not what is in question. The relinquishment has happened. They are not saying that it is not relinquished. Relinquishment has happened. The question is whether it can be leased back or can be given for maintenance. And this court has held that 89 rules will not apply. We don't need to explain this to you. 89 rules will not apply and it can only be given for maintenance. At the time of maintenance, some conditions can be imposed. So what are those conditions? If you are going to evaluate as annuity, you are not permitted to do that.
My lord, we have taken this time. What we are stated in the application. My lord, the 2015 revised master plan for which the petitioner is relying upon. There is point number 7, which came into force from 22/6/2007.
25/6/2007. RIT came into force.
22/6/2007.
That was sent. The file was sent. 25th was the notification.
Plan came into force. That is revised master plan 2015, which came into force from 22/6/2007. Now, my lord, so far the petitioner case is concerned, their housing project was approved as per the zoning of land use and regulation comprehensive development plan 1995. That was the law which was in force prior to 22/6/2007. The same was approved on 19/12/2005. Now, if I take my notes to the zoning of land use and regulation of comprehensive development plan 1995, where it speaks that
all those are irrelevant, Mr. Sachin.
only 25% area to be reserved for CA park open space, and other area has to be, and area reserved for parks has to be relinquished to be PD. That's what the
Sachin, you don't expect BDA to do the right thing every time. What we only expect from a council is if there's a mistake committed, mistake item, mugitu. A mistake ne justify ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ then we'll have to hold it. As you have not applied the decision of this court. Despite that, if you want to address, you are free to do it. But then we are free to only you say what about para 13 of the judgment. All your conditions have been dealt with. Not I don't re-argue that because you'll be arguing against judgment, not permissible. We can't permit you to do that.
But my lord has to see the representation. That's the best representation we had acted upon. 86 representation. Now he's going what I told you. 86. The petitioner's representation
page 117 of the writ petition, dated 7/10/2015. 117.
Yes. What about this?
This is the representation given by the petitioner.
Yes. What do you want to learn?
That is last paragraph. We request you to allot all civic amenities and park areas in favor of us to provide all the necessary amenities. We
Yes.
gave it. So he is requesting for allotment. It's not a case of the petition that is use land for maintenance.
Yes.
So therefore, now the petitioner cannot contend and say before the court saying that
So have you allotted? Are you going to allot?
why not the allotment of civic amenities site is not permissible. Only it has to be leased out as per
So
the
don't pick words to suit your requirement.
So rule says that.
So if you are going to allot, then use the word allot to your advantage. They've asked, have you allotted? Will you allot?
But we have leased.
Then,
As per the civic allotment of civic amenities.
okay, certain the last time that we'll be telling you. Then after that you won't like it. So they give you all opportunity. You can consider some amount, you can impose some conditions, but not on annuity. Petitioner is before this court seeking for the following relief. The petitioner is an association of persons comprising of the purchasers of apartments in the building known as, in the project known as Windmills of Your Mind, constructed by respondent number 2, by petition number 2 in various survey numbers at Woody and Sonenaldi village, KR-Puram, Bangalore. At the time of seeking for development plan and building plans, in terms of the applicable rules, the second petitioner developer had relinquished parks and open spaces as well as civic amenity sites to the respondent BDA. Upon completion of the construction and at the time of issuance of occupancy certificate, the first petitioner association, supported by the second petitioner developer, had approached the BDA seeking for allotment of the parks, open spaces, and civic amenities comprised of in the development. In pursuance thereof, respondent communicated the intention, the agreement to to lease the said area to the petitioner for a period of 30 years and issued allotment letter dated 12/4/2016. However, while doing so, the respondent imposed a condition of making payment of lease rentals on annuity basis. It is agreed by the same that the petitioner is before this court seeking for the opposite relief. G. Sridhar, the counsel for the petitioner, would submit that the manner in which wide Annexure G, namely the allotment letter dated 12/4/2016, the respondent has sought to value the lease rentals is not permissible, since what is being given to the petitioner is a right to use the civic amenity comprised of in the development in which the petitioners, the members of the petitioners are owners, and this court, as in the decision dated 13 July 2011 in WP number 12689 of 2011, categorically held that the BDA allotment of civic amenity site rules 1989 would not apply, and it would be Regulation 7 and 7.1 of Chapter 7 of the zonal regulations, which came into force in the year 2007, which would be applicable to the case of the petitioner. At the most, there could be certain conditions which could be imposed, but not lease rentals on the petitioner. He submits that therefore, the condition of payment of lease rentals imposed in the allotment letter dated 12/4/2016 is not proper. He, however, submits that the petitioners would comply with any reasonable direction and or condition imposed by the respondent. Shri B.S. Sachin, learned counsel appearing for the BDA, submitted that since the plan sanction of the petitioner has been secured prior to the revised master plan 2015 coming into force in the month of June 2007, the revised master plan would not be applicable to the petitioner, and it is the comprehensive development plan of the year 1995 which would be applicable to the petitioner, in terms whereof only a lease would be granted in favor of the petitioner and requiring the petitioner to make payment of lease rentals. He further submits that the calculation of lease rentals is proper and is based on the is proper. Based ನೀವು ಹೇಳಿಲ್ಲ ಏನು ಹೇಳಿದ್ರಿ ಅಂತ ಎಷ್ಟು ಮತ್ತೆ ಏನು ಹೇಳಲಿ. He therefore submits that the relief sought for by the petitioner cannot be granted. Correct. Third, Shri G. Sridhar, learned counsel for the petitioner, Shri B. S. Sachin, learned counsel for the respondent. This court, in while it's ordered dated 13/7/2011 in WP number 12689 of 2011, at para 13, as held as on the page 13, para 13, page 13 and 14. This court has, while considering the very same issue as in the present matter, has categorically held that when there is a residential development plan which is sanctioned, it is Regulation 7 which would be of the zonal regulation which would be applicable. And any area reserved for park and open space relinquished to the authority can be given back to the local residents for maintenance. Any such handover is only for the purpose of the maintenance of said area by the residents association and or by the developer, and such handover would not amount to disposal of the site, requiring the application of the BDA allotment of civic community site rules 1989. This court has categorically held that the said rules of 1989 would not be applicable in such a situation, and that it is when and further that it is only when a civic community site is reserved for a particular purpose in terms of Rule 3 of the 89 rules that the disposal of the site, civic community site, can be made on the basis of lease rentals to be paid. Correct. In view of the above, it is clear that the BDA, while disposing of a while handing over open space, park area or civic community site to the residents of a residential development which has been approved, which is implemented by a developer and approved by the BDA. The BDA can only hand over the open space, park areas and civic community sites for maintenance, and there is no title which passes to either the residents or the developer. Such being the case, when there is no transfer, lease being a transfer under the Transfer of Property Act 1882, the concomitants of a lease under the Transfer of Property Act would not be applicable to the present case, requiring payment of lease rentals on annuity basis or otherwise. This court, in a Catena decision which have followed the aforesaid decision, has reiterated the said view. Hence, it is rather shocking that the BDA, despite being aware of the decisions passed by this court, has continued to levy these rentals whenever a open space, park area or a civic amenity is handed over to the residents of the area. In view of the decision of this court, which is applicable on all fours to the present case, I have the considered opinion that the BDA cannot resort to levy of lease rentals. However, the BDA can impose certain conditions as regards the maintenance of the said area given to the residents, which are required to be reasonable. In view thereof, I pass the following order. A certiorari is issued. The condition imposing payment of lease rentals on the civic community sites by allotment letter dated 12/4/2016 at Annexure G is quashed. The respondent is directed to consider the representation dated 8/8/2016 of petition number 1 and hand over the open space, park areas and civic amenities to the petition number 1 by following the directions issued by this court in WP number 12689 of 2011. Petition stands disposed.
Because as per the new rule also there is certain percentage under which we can hand over to. As per the 2015 rule, only 5% of the land which can be handed over. That's what the rule says.
The other continuous should be a certain learned counsel is that the development plan was sanctioned prior to the year 2005 and therefore RMP 2015, which came into force in June 2007, would not be applicable. In my considered view, the said submission would also be untenable for the reason that the application being made by the petitioner is in the year first petitioner. The petition number 1 is in the year 2014, when the RMP 2015 had come into force. The application would have to be considered as per the applicable law as on the date on which the application is being filed and not on a date on which the plan sanction was granted, which admittedly has also been modified after the RMP came to force in the year 2009. Thus, this contention also stands rejected. And what is that?
As per the new regulation.
Regulation of?
Chapter 7. RMP 2000.
What is zonal regulation?
Regulation 7.1.
Yes.
That my lord, it is being called out in the very restriction itself. At page number 8, ground number 16.
Yes, please.
10% of the park and open spaces used with the authority may be allowed to be maintained by the local residents association
and 5% in the area reserved for free shall be added to the with 10%.
What's your contention? We are not able to understand.
Total park is only 10%.
10% release ಮಾಡಿದ್ರಲ್ಲಿ 10% ಮಾತ್ರ ಕೊಡಬಹುದು.
10% of the land shall be reserved for open park and open space. And open space shall be released to the authority free of cost and shall be allowed to be maintained within open space.
We want to pursue that submission, Mr. Sachin. ಇನ್ನೊಂದ್ಸತಿ ಓದಿಬೇಕು. ಬೇಡಲ್ಲ ನೀವು ಓದ್ಬಿಟ್ಟು ಹೇಳ್ಬೇಕ್ರಿ, ಸುಮ್ನೆ ಹಂಗೆ ಕೊಟ್ಬಿಡ್ತೀರ. ಅಲ್ಲ, ನಿಮ್ ಪಕ್ಕದಲ್ಲಿ ಇರೋರ್ಗೆ ಹೇಳ್ತಾರೆ.
I appear for the respondent.
Yes. Last time ಅದೇ submission ಮಾಡಿದ್ರು. Fastest ಹೇಳಿ. Article 14 violation ಆಗುತ್ತೆ. The imposed cost. Lakshmi has to pay cost, so you also have to pay cost. ನೀವು ಹೇಳಂಗಿದ್ರೆ ಹೇಳಿಲ್ಲ, ನಾವು ಹೇಳ್ತೀವಿ. ಆಮೇಲೆ ನೀವು Land counsel for the petitioner once again seeks for time. Even on the last occasion, the counsel had sought for time. There is no indulgence which is required to be extended to the petitioner. However, in the interest of justice, one last opportunity is granted. We list on 28(6), subject to payment of cost of ₹1,000 to the advocate's library fund within the set period of 1 week.
Serial number 38, my lord. 39.
39.
Much. I appear for respondent number 4.
Yes, 104. ಬರ್ಕೋಬಿಟ್ರಾ? ಅದಕ್ಕೆ ಮತ್ತೋದ್ರೆ
Thursday because I did 3 days for it. But I like to that what information I will not ask me. The specific question how the once the site how the there can be change in the participation.
No, the contention of Mr. Manjun Reddy, the senior counsel, is that under the disposal of corner site and stay site rules, because of your notification, they can only do it by way of an auction. They cannot allot it to anybody else. Because it is you are the boss. If you direct BDA, yes, you allot, they will allot. Would you as a state come to the rescue of the hapless citizens who are now left with no sites because of whatever reason? That will come to later. Because the contention of Mr. Reddy is that BDA does not have the money and they won't be able to implement the development of the layout. Therefore, they should be allowed to sell. The second line of argument is, even if there is a stay granted by this court, those sites which are prevented from being sold will not inure to the benefit of the petitioner because they are governed by the corner site rules. So there are only two solutions. One, you direct them to allot corner sites, or as this court has directed in various matters, this court will direct the allot. But being the state, the prerogative is yours. What you want to do to come to the rescue of the citizens. And Ms. Reddy, one more thing we forgot is you will have to give us a list of all the civic community sites and stay sites so that we know what the value is.
Give a list of allotments. You need to know because our information is they're going on allotting. That might be.
Because we.
With the dates. With the dates of allotment. What happens? This layout was taken somewhere in 2006.
No, there should not be any fresh allotment.
Fresh allotment. There are no fresh allotment. Only in respect of people who have lost their sites. And now, when the site was, when the layout was passed, there was no 40-60 scheme.
Yes.
Now the 40-60 scheme, for the sector, there is a now, what has happened is many of you who are not updated on sites.
They have to be.
40-60 sites.
No problem. You have to follow the directions. Only thing is that which are the corner sites. Even the state will require those details. Corner sites, stay sites, and whatever site that you want to auction. Those details, even the state would probably require it for them to take a decision. It did not strike us that day until now, Mr. Krishna mentioned. We will ask. Shri B.V. Krishna, learned AGA. Yes, who are you? Which matter is yours? 100, we are not in 100, we are in 104. So you don't want to be part of this group. You don't want to be part of this. The counsel for the petitioner in 104.3 submit that the said matter is not connected to the above matter and therefore seeks for the matter to be disconnected. Dealing WP number 15890 of 2021 and relist on 12/7. The other matters, Shri B.V. Krishna, learned AGA, submit that he has unfortunately not been able to secure instructions. And given a week's time, we will secure instructions and make a submission as per the order passed on the last occasion. In order to facilitate the submission of the learned AGA, the Bangalore Development Authority is directed to furnish the following details to the learned AGA, as also file the same before this court. 1. List of list of all corner sites with their site numbers and dimensions. 2. List of all stray sites with their site numbers and dimensions. List of all sites which have not been allotted till date. List of all. ಯಾವ್ದು ಅಲಾಟ್ ಆಗಿಲ್ಲ ಅಂತ ಕೊಡಿ, ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡದೇ ಇರೋದು. ನೀವು ಸೈಟ್ ಅಲಾಟ್ ಮಾಡಿದಿರೋ ಇಲ್ವೋ? ಅದೇ ಬೇಕಾಗಿರೋದಲ್ಲ ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಏನು. And whatever the reason that you want. So if you can't furnish, please say what the reason is. Let them also consider. If your information doesn't flow there at all. List of all sites allotted. List of sites unallotted with the site numbers and measurements. List of all sites allotted till date with site numbers, measurement and date of allotment. Relist on 28/6.
One request, serial number 104. Yeah, what about EV Krishna for R2? In our office, they will never recognize by name. They recognize by either Malad additional applicant
Yes.
AG or
The registry is director of print. ಏನಂತ ಬರ್ಬೇಕು?
EV Krishna for R, AG for R.
Print, the name of Sri B.V. Krishna is Sri B.V. Krishna, learned AGA for respond number 2. Okay. Only in Puttra, wherever B.V. Krishna takes learned Sri B.V. Krishna, learned AGA. And the registry is like the print as such. The registry direction. Yes, Mr. You want?
Some of them are already there because we look at them and get education and registration. Other than that, initially we will not be able to function because our say allotment
ನೀವು ಅಲಾಟ್ಮೆಂಟ್ ಲಿಸ್ಟ್ ಒಂದು ಕೊಟ್ಬಿಡಿ ನೀವು ಯಾವ ಮಾಡಿದೀರಾ ಅಂತ. So it stops there. Whatever the committee decides. So the idea is only to see to it that you don't allot, your client doesn't allot anything more now and creates more problem. Because that date needs to, somewhere it has to stop. Illa, Mr. Reddy, only this matter alla. There are hundreds of matters relating to this. Hundreds of matters relating to this affair. ಎಲ್ಲ ಅಲ್ಲಿ ಕಳಿಸ್ತಾ ಇದ್ದೀವಿ. ಇವಾಗ ಈ ಬಫರ್ ಝೋನ್ ರಾಂಗ್ ಇದರಲ್ಲಿ
in order to ensure that proper one is maintained at 25 meters, I will be directed by the we are going to pay a task. Other than sites, Karnataka, you put in 50-80 sites now 20, 30, 40. The same landowner, we have the landowner over here. If you are 40, 60 schools, we have allotted these sites with them. They have a effect for it. They get them landowners. That's what legally is here. That is why, since the entire way of pertaining to this they are and we have to accommodate for support participation. And the two sites have been deleted up here, not there. Because this is the mistake, they are not accommodating them.
that is not a fair way of doing it by a statute.
No sites there.
A lot this corner sites. We have corner sites. Okay. Our ಕೇಳಬಿಟ್ಟು then if they say that if they are agreeable, we'll record their submission.
They cannot also issue direction under section 62 or 65 of the BDI Act. Contrary to the law.
Let us see what they say.
What is not provided for the law. Corner sites are only by public option.
And we'll keep the corner side like that only. We'll keep that. So this court and so many matters has directed you to allot corner sites when there is injustice caused to the allottees. We consider that. So look at the situation that BDA is doing. You make your mistakes. You say now this site is not there, and you say that now. Correct. Now let's take it a little further. What is the value of this site here in Arkavati? And what is the value of the site you are giving there? Are you giving the same value there?
We are not taking any extra money from them now. Whatever is the price for this table, allotted a site. No, the same site is being allotted. Unfortunately, all this is being monitored by the Supreme Court.
They bought a Honda Accord, now you are giving them a Honda City. Kashta.
It's a registered sale deed executed. They lost title over this land. But does not mean that I have given them a carbon site, a contrary to law, unless and until that's what action said.
How did, there are various issues. What Mr. Paninda is saying is right. After doing a sale, how did you do that?
They didn't have title over my land.
A lot of issues. It was pointed out last time when we passed the.
Meantime, that is the case with us. There are certain carbon sites here. There are about 6 or 7.
Hey, stray sites allot ಮಾಡಿ ಕಾರ್ನರ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಅದೇ ಲಿಸ್ಟ್ ಬರ್ಲಿ ನಿಮ್ ಡೇಟಾ ಬೇಸ್ ಇಂದ ಬರ್ಲಿ ಎಲ್ಲ ಏನ್ ತೆಗೆದು ಅವ್ರ ಇಷ್ಟ ಸ್ವಲ್ಪ ಕಮ್ಮಿನೂ ತಗೊಳ್ಬೋದೇನೋ ಒಂದು ಆಫರ್ ಮಾಡಿ ಜಾಸ್ತಿ ಇರ್ಬೋದು ಜಾಸ್ತಿ ದುಡ್ಡು ಕೊಡ್ಬೋದು ಕಮ್ಮಿ ಇರ್ಬೋದು ತಗೊಳಕ್ ರೆಡಿ ಇರ್ಬೋದು ಆಫರ್ ಆದ್ರೂ ಮಾಡಿ so that people's problems are sorted. You cannot be unilaterally deciding everything. ಅವರಿಬ್ಬರದು ಕೆಳಗೆ ಬಿಟ್ಬಿಡಿ ಅವರಿಬ್ರು ದೇರ್ on the as a senior counsel we would want your guidance on that. ಅವ್ರು ಬಹಳ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ನಿಮ್ ಲೆಫ್ಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇರೋರಂತ ಅವ್ರ ಲೆಫ್ಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇರೋದು we won't use the name ಲೆಫ್ಟ್ ಅಲ್ಲಿ ಇರೋರು ಗಲಾಟೆ ಜಾಸ್ತಿ come up with a solution for this. ಅವ್ರ ಪಾಪ ಅವ್ರ ಕಷ್ಟ ಆಗತ್ತೆ we understand their difficulty ಅವ್ರು ಮಾಡ್ಲೇಬೇಕು ಗಲಾಟೆ ಅವ್ರಿಗೆ decision we are only facilitating tomorrow if the government says
whether it is possible for the Bangalore development to find out some protection the same layout of the same dimension. Otherwise,
we are looking at where if the state government says no, if the state government says tomorrow we are going to give you 200 crores, develop it.
Once the scheme is approved, this the instrumental.
Even if they can't issue a direction under section 65 to become contrary to the rules, they can't issue unless and enforce my directive.
You explore the possibility of some other sites also where we can offer them.
We have given impact words which show what can be done. But if we is so thing, what they say is if you have got 30-40 sites like this, or can extend it like this, that becomes an odd dimension. That those sites are already been allotted to the landowner. I say if you are going to allot it to somebody else, not to somebody else, the landowner and
the existing stray sites anywhere, ನೋಡಿ ಇರುತ್ತೆ.
In fact, the direction is there.
Let them have an open mind. Let them not have a closed mind.
I was sitting there and I was speaking to the commissioner. I spoke to the commissioner myself on Friday. I told him to explore possibility if there are sites which are not in litigation or without even going before the justice department.
That's why we are very happy that you are appearing. Some solution could be found. ಅವ್ರಿಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ ನೀವು ಅದು ಸೊಲ್ಯೂಷನ್ ನೋಡ್ಬೋದು.
Morning also when I was reading the papers before coming to this court, I asked him whether it is possible, whether it is done before that something can be done in this level itself. His hands also are right now because I will try to find out. Anyway, I told him.
Once the data ಬಂದ್ಮೇಲೆ you can make a decision.
But that's something because the entire thing is before the justice department. That is the difficulty.
If it is there, then we will send them also there.
Great respect. That is not so. Yes. Let's not bring the committee into this. I know that the committee that I am not you. Committee's hands are also very limited. I am fine.
New list ಕೊಡಿ.
Here this 6 years, so many cases are
We are sending every day, every Tuesday we are sending. ಇನ್ನ ಇದರಲ್ಲಿ ಇವಾಗ ಮತ್ತೆ ಕರೆದಾಗ ಎಷ್ಟು ಹೋಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. ಇದು ನೋಡಿ ಇದು ನೋಡ್ಬಿಟ್ಟು then we'll see.
To explore the possibility of bringing them inside there. That submission I did not want to make because they have one at least in my development space as a judicial area. Only buffer zone one. Whether we can accommodate these people in the same level as asked them to explore that possibility even without the court.
No, let's say also hear the state as to what the state wants. ಎಲ್ಲ ನಿಮ್ ಡೇಟಾಬೇಸ್ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಇದೆ.
Instead of that,
Last direction we'll delete as regards the allotment. Corner sides, stray sides, adella will remain. We won't conduct a roving inquiry. What the government requires is only corner side and stray sides to decide on. That may not be required. There won't be end to that, Mr. Panindra. They will take 3 months for that to happen.
Not the entire allotments. Modified plan came only.
Well, not. How is it relevant for you?
Because now, under the modified plan, my site has been destroyed, and they say I have given somebody else this site. That site I am making the submission of.
That is 40-60 or not.
40-60 we have given to the.
With a lesser measurement.
Of my site. Not my site. In the original plan, my site is there.
You are okay with the lesser measurement of 30-40?
Yes, that's the proposal I gave. No, he wants the same proposal. They say proposal like this.
Nimma site ಎಷ್ಟು extent?
It was 58. North, south, was about north, south is 50. West and east was 80 feet. Now, west and east is a buffer zone problem. They have cut it and made it into about 38 feet. 50 feet remains. I said, you can leave that. I will remain with 28 feet. But the extent is 50 feet, which is not so.
Mr. Panindra, this was a submission made by your instructing counsel. We asked him only one thing. Has he seen the building bylaws? If you see, no, you can't violate the building bylaws.
No, I will not violate.
If you get 30 feet in the frontage, 16 feet has to be left in the front. So you will be left with only 14 feet. What will you build? A line of shops?
My allotment says it becomes unworkable. They are going to allot the same site to somebody.
30-40 is different than this size.
30-40, I will.
Mr. Panindra, please go see the building bylaws. Let's not discuss this.
I understand the building bylaws. I am saying the same layout.
Do one thing. We told your counsel also, he apparently has not done the homework. And he is still persisting with that, which is now.
They can give it for 30-40 sites. That's how they have to work out. Some alternate mechanism. In the system, there is same site. Not the same site.
If you are going that line, then it cannot work.
No, I am not saying that. They have to come out with. Therefore,
so allow them to come, no? Allow them to come. That's what we are directing them. So until then, please have some patience. Hold your horses. Have some patience.
The modified plan, at least they can come up with allotments made pursuant to the modified. Why do you need it?
Mr. Panindra, it will take us one line order to send you to the committee.
Why do you need it?
If you want to do that, we will send it. Be reasonable and have some patience.
I'm just saying I'm giving them alternatives.
Not here, not here in this discussion. There's not a statement to be made here. When 28. Our last item thing. Civic community, stray sites. Adhirata. Civic community, sorry, corner sites, stray sites. Auction sites. At the last line.
That's already there. the same dimension or lesser.
ಅಲ್ಲ ನಿಮ್ ಸಬ್ಮಿಷನ್ ನಮ್ ಡೈರೆಕ್ಷನ್
ಡೈರೆಕ್ಷನ್ ಇದೆ ಸಬ್ಮಿಷನ್ ಅಂತ
ಡೈರೆಕ್ಷನ್
ನಾನು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರಕ್ಕಾಗಲ್ಲ.
ನಿಮ್ಗೆ ಯಾವ ಪ್ರಾಬ್ಲಮ್ ಆಗಲ್ಲ ಬಿಡಿ, ಅಲ್ಲಿ ಹೇಳ್ಬೋದು, ನಿಮ್ಗಿಲ್ಲ. That is why we are happy that you had appeared so that you can resolve these issues. The BDA, the Commissioner of BDA is also directed to look into the matter to explore the possibility of amicably resolving the matter, the issues by allotting alternate sites within the Arkavati layout.
Even if it is a smaller dimension, then we can offer the same dimension or lesser dimension.
Or the same dimension, or the dimension greater than, equal to, or lesser than that allotted to the petitioner.
Formation agreement 58 is ಜಾಸ್ತಿ ಇದೆ. We will offer 46. Some people may take 40, 60 and be happy with it.
ಅಷ್ಟೇ.
Be happy with it. Lesser dimension, more dimension.
More ಇಲ್ಲ, equal to or lesser
50, 80
ಮಾಡಿಲ್ಲ. ಈ ಸೈಡ್ ಬಿಟ್ಬಿಡಿ, ಇದು ಬರಲ್ಲ, ನೆಕ್ಸ್ಟ್ ನೋಡೋಣ. ಏನು ಆಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಅದನ್ನು ಆಗ್ಬಿಡಲ್ಲ ಅಂತ. ನೆಕ್ಸ್ಟ್
everybody should be flexible in our transformation.
That's what we are telling you also.
We are being more flexible. Now we are government set for rules with the four direction.
Yes. 40. ಏನಮ್ಮ IA2 of 27 ಏನೋ 5/7. So DD file ಏನಂತೆ? Since the above matter will be taken up for final hearing, consideration of IA number 2 of 2017 at this stage does not arise. IA2 of 17 stands dismissed. CL number 12, connect the above matter with CL number 12, and when is it listed? 28. Interim order is extended. Ms. Rama Iyer has entered appearance for the petitioner. Delete the name of Sri Madhukar M. Deshpande as that appearing for the petitioner. Yes, 12. Shri N.R. Girisha has entered appearance. Delete M.N. Sudhir Vegade.
41 adjust, 44. Consultation.
You are appearing for R1, Mr. Judicial. B.S. Sachin has entered appearance for respond number 1. He accepts notice for respond number 2 also. Registry the I delete the name of Sri Vivek Yaugal as that appearing for R1 and R2. R3 Ariola. Who is appearing for R3? Serial number 42. Dispenser. But is Jana is a Kempana Jagdishwara State Council. More history that dispense agate sadhya illa. Who is R3? So Jagdishwara. Somebody will have to appear for R3. Nobody has filed wakalat. ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ NOC wakalat filed. Sorry, not filed. Shri N.R. Jagdishwara has entered appearance for respond number 3. Delete Kampanna on the name of State Council as that appearing for respond number 3. You have filed your objections? What about any relief against respond number 3? Respond number.
They are formally designed for what they have given me amalgamated khata is and I am contending that after verification of the entire title deeds, they have given amalgamated khata which do not tally with the early enforcement made by the second respondent.
So respond number 3 would be required. None appears for the respond number 3 today, though the council, though learned council, senior counsel for the petitioner is present and ready to address arguments. Released on 28/6, if none were to appear for respond number 3 on that date, the matter would be taken up for consideration in their audience. One notice we'll have to say, if they don't come, we'll take it up. Our Barlilla andre Barlilla. 28 okay na? 4th time. Interim order ಏನಿದ್ದಂಗಿಲ್ಲ. No interim order. ಬಹಳ ವರ್ಷಗಳಿಂದ ಕಂಟಿನ್ಯೂ ಆಗಿಲ್ಲ. The interim order was only in 2017. After that, it's never been extended. Never been extended. So we can't do that. Not after 5 years. We'll take it up on 28 or 4th, whenever they come. K.V. Monish Kumar has entered appearance for the petitioner. Delete the name of Praveen Kumar. So who is appearing for R1 now? Or is it Krishna or Esther? Is that?
K. Krishna is appearing for R1, my lord.
Or either a panel ali hoga. Panel ali illa.
He was not appearing. That's why he was registered.
ನಿಮ್ಮನ್ನೇ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ 15/11/21. ಕಾಪಿ ಟು whom? ನಾವೇನ್ ಮಾಡೋಣ? ಇಂಟರ್ನಲ್ ಪ್ರಾಬ್ಲಮ್. No bilateral discussion. You want full set for the Mr. Manish? With all objections, Shri K. Krishna has entered appearance, who has been directed to enter appearance by order dated 15/11/2021. Hence, registry is directed to delete the name of Shri G.M. Chandrasekhar and Natraj, CD, as that appearing for R1. R4 ಯಾರು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ? ಕೆ. ಅರುಣ್ ಕುಮಾರ್, ರೇಷ್ಮಾ ತಮ್ಮಯ್ಯ, ಯಾರಮ್ಮ? Shri K. Krishna, Learned Counsel, submits that he has not received He does not have the papers in the matter. Hence, he does not have the papers. Hence, Sri Monish Kumar, the counsel for the petitioner, is directed to furnish copy of the petition along with annexures, as also any statement of objections filed by the other counsels along with annexures on Sri K. Krishna. In R4, then Ms. Reshma Tamay has entered appearance for respondent number 4 in the registry that delete the name of Sri K. Arun Kumar and K. S. Ponnappa as that appearing for respondent number 4. Objections Akidara R1. No? Your file, Mr. Your file. R3 has filed, Mr. Shetty.
No, my lord, we are not yet filed, my lord. A week's time we'll file the objections, my lord.
Counsel Sri K. Krishna seeks for and is granted 2 weeks' time to file a statement of objections. Sri Shashikaran Shetty, learned senior counsel appearing for respondent number 3, also seeks for and is granted 2 weeks' time to file a statement of objections. R4 Akidara. Three weeks. File agidya. File agidya. Objections, if any, to be filed on or before 14/7, relist on 19/7.
Get 50, my lord.
Shankar Rao, idara panel alli. Ide agide team. So there is the list of panel articles indicates that Sri B.G. Shankar Rao is no longer on the panel of the BDA. Hence, Sri Vijay Kumar Desai, another panel advocate, is directed to take notice for respondent number 1 and 2. Registry is directed to delete the name of Sri B.G. Shankar Rao as that appearing for respondent number 1 and 2 and print the name of Sri Vijay Kumar Desai. Counsel for the petitioner to furnish a copy of the petition along with annexures on the said counsel. Objections, if any, to be filed on or before 14/7, released on 19/7. Yeah. So 2019. Dadmel ilva illa.
I'm seeking the writing.
For what reason?
This is a option notification issued by the BDA by virtue of which BDA seeks to sell a property of which I am claiming ownership by adverse possession, and I have filed a suit.
What does that mean? You go and ask for injunction there. Not here.
No, I can, of course, I can see injunction in the report. I'll explain it. What happened?
And the suit you have filed against BDA.
I filed a suit against BDA, which your lordship will find the date I have filed, date 42.
Yes.
And pursuant to filing of this suit, may I request your lordship to kindly turn to annexure E, page 51. They issued one endorsement.
Whatever it may be, Mr. Hegde, you have a suit.
Let me just explain. I can't go before the civil court. The suit has just now been restored after the Honorable High Court allowed my liquidation on GMCTC. This endorsement was issued by the PDA, page 51, Your Worship, where they confirm that I am in possession.
Mr. Hegde, the test that would apply to that court and the test that will apply to this court would be different. Unless you come with a clear categorical title, we cannot accept you. They're pending, they can pass an order.
Let me explain what the position is. Pursuant to issuance of this endorsement by the PDA and XLD page 51, I filed a memo for withdrawal of this, which Your Lordship will find with the previous page.
What is the memo which is filed? What is the endorsement issue?
Endorsement, Your Lordship, is turn to page 51, what they say. Kajakunahally Gram, the unnumbered paragraph number 3. Survey number 17, the LJ 3 exam here, movement block down in the part 5, consumer years hour different place to Abdul Majid, being late Abdul Razak Kaura, Ali compound ನಿರ್ಮಿಸಿಕೊಂಡು ಅನುಭವ ಮಾಡುತ್ತಿರುವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಒಂದು ಎಸಿ ಶೀಟ್ ಶೆಡ್ ಇರುತ್ತದೆ. ಸದರಿ ಪ್ರದೇಶದ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಆರ್ಸಿಸಿ ಕಟ್ಟಡದಿಂದ ಆವೃತವಾಗಿದ್ದು ಪೂರ್ವ ಅಭಿವೃದ್ಧಿಯಾಗಿರುತ್ತದೆ ಎಂದು ಪ್ರಾಧಿಕಾರದ ಭೂಮಾಪಕರು ನಕ್ಷೆಯೊಂದಿಗೆ ನೀಡಿರುವ ವರದಿ ಆಧಾರದ ಮೇಲೆ ಮಾಹಿತಿ ಇರುತ್ತದೆ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಲಾಗಿದೆ. They confirm my possession over the property and kindly turn to the next page 52, and your Lordship will find 410 on the right hand side. That is the side, and page 53, Your Lordship made. All these are forming part of the endorsement. They confirm, though my possession is with respect to 7,000 square foot, which according to me has no cycle number, because that was not the description, but DDA calls it to be site number 400, and they locate or identify my property to be their property bearing number 410, and that is the endorsement they give. They confirm that I am in possession. Based on this confirmation, Lord, I filed this memo, which Your Lordship will find on page number 54, the next here.
Yes.
Plaintiff opponent most respectfully submits that the defendant has issued an endorsement dated 16/7/2014 along with a sketch wherein the defendant has confirmed title over the suitable property rests with the plaintiff. The cloud over the title of the suitable property has been here in view of the aforesaid. A copy of the endorsement.
You are claiming adverse possession. How can a cloud be clear?
Likewise, it would have been better.
You don't even have any
I am
title.
only claiming adverse possession. My suit was still there.
You have no title.
Now, since they issued this, I assume that they admit my ownership, and therefore I sought dismissal as withdrawn. Based on this memo,
Bad advice.
the trial court passes this order interestingly, which Your Lordship will find
Dismissed
that
suit of dismissal are not known.
page 57 order was passed by the trial court. The trial court dismissed my memo as well as the suit as not meant to be. Based on the judgment of the Honorable Supreme
Yes. Have you challenged the acquisition?
Yes, this was challenged in the writ petition, which Your Lordship will find the next page.
Have you challenged the acquisition? Have you challenged the acquisition? BD has acquired this. Now,
I have not
BD has formed this layout.
But I am not challenging the acquisition. I cannot challenge the acquisition at this stage. And my challenge was that I am in possession, which possession is confirmed by the PDA in an endorsement issued by a.
Okay, you are in possession. That doesn't mean you are in lawful possession.
Today, Your Lordship knows the law, that the adverse possession is not merely left as a shield. It's today a sword in my hand, and therefore I filed a suit for declaration, which suit was pending when the endorsement came about, and then I withdraw the suit. I file a memo for withdrawal,
the trial court dismisses my memo as well as the suit, against which a writ petition had been filed 874, the lordship will find the writ petition.
Now it has been revived.
Now that the suit has been revived. Suit has been revived and this order, may I pass on this?
So now you go before the suit and ask for the injunction, Mr. Brigadier.
No, my recommend, my lord, the lordship may say so that your lordship may kindly protect my possession and send me to trial court to Lord. Now the suit has been restored and the suit has to go on from where it was pending. And in fact, I have now abandoned the memo which I had filed and prosecuting the suit before the trial court. And your lordship may kindly protect, let BDA not do anything, precipitate this e-auction notification and create third-party interest. Protect my interest to that limited extent. And when
We will protect you for a week. You file your applications there. It will be, you ask for injunction there, it will be considered in accordance with law, not as here.
Absolutely. But in the meantime, let the auction notice notification not be given effect to and third-party interest be created.
Mr. Brigadier, this is a 2017 notification. You are asking for a stay in 2022. We can't grant this.
There is a stay.
So
There is a stay, interim order operating against them.
this is an abuse of the process of the law. We have to dismiss this by imposing costs. You file a suit, you file a writ petition. What is this?
But when I filed the writ petition, the suit was not there. That's the difficulty. When I filed,
The suit was not there.
suit was not there.
2012 is your suit.
I know, I returned the suit. Not 2017 notification. I assumed that everything is over. And BDA suddenly issues this notification after I had filed the withdrawal memo and
Wrong assumption, Mr. Brigadier. Wrong assumption. You are asking for adverse possession. How can the cloud be lifted? In dinner, title will only come if there is a decree passed in your favor.
Very true. Very true. I go on to the absolutely no second question about it. Now
You ಅದನ್ನು withdraw ಮಾಡಿದ್ರೆ ಏನೂ ಇಲ್ಲ.
ಈಗ ಇದೆ. ಅದು ಏನಾಗುತ್ತೋ ಆಗಲಿ. I am not saying let it attain its rate.
We can't decide in this. We can't decide on the. That will have to be decided there. The court will decide whether to grant an injunction. No, we are not granting them any relief at all. We are only relegating them to the trial court. We can't pass any orders in this. ಅದಕ್ಕೆ ನಾವು ಆ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡೋದು ಕೊಡತ್ತಾ ಅಂತ ಇಲ್ಲಂತೂ ನಾವು ಕೊಡಕ್ಕಾಗಲ್ಲ. They have no crystallized right. ನೀವು 5 ವರ್ಷದಿಂದ ನೀವು ಸುಮ್ಮನೆ ಇದ್ದೀರಾ ಏನ್ ಮಾಡೋದು? Petitioner. The petitioner has challenged the notification dated 17 December 2017 issued by respondent BDA seeking to auction the site number 3AM-410. It's not in dispute that the petitioner has no recognized title as such in its favor, and the petitioner has filed a suit in OS number 7024 of 2012 seeking for declaration of title by adverse possession. If such a suit has been filed, the present writ petition is not maintainable. Since such a suit has been filed, the present writ petition is not maintainable. Hence, the writ petition is dismissed, reserving liberty to petitioner to seek for any interim reliefs as sought for in the present matter before the trial court. Auction ಏನು complete ಆಯ್ತಾ? Have you confirmed any? Because if the auction is lapsed, then there's no need to extend the interim order also. But then you will have to make a submission. See, Ganapati Agde, Leonard Senior Counsel submit that the benefit of the interim order earlier granted may be extended till the extended to the benefit of the petitioner she has to enable the petitioner to approach the trial court. Shri B.S. Sachin, learned counsel for the petitioner, or for the respondent, submit that the auction notification of Annexure A has spent itself, and as such, there is no purpose served by extending the interim order. In view thereof, reserving liberty to the petitioner to approach the trial court seeking for such relief as the petitioner intends to, the petition stands disposed. ಏನ್ರಿ ನೀವು ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಇದಾರ ಎಲ್ಲಿದ್ದಾರೆ ಇಲ್ಲ ಇದಾರ ಮಿಸ್ಟರ್ ಕೃಷ್ಣ ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಇವತ್ತಿನ ಲಿಸ್ಟ್ ಆಯ್ತು
ಅದೇ ಇವತ್ತಿಂದ ಸರ್ ಸೇರಿಸಿದ್ದೀನಿ ಆಡ್ ಮಾಡಿ
ಎಲ್ಲಿದೆ ಬಿಡಿ ಅಲ್ಲ ಏನು ಆಡ್ ಏನು ಮಾಡಿದ್ರು
ಅಲ್ಲಲ್ಲ ಹೊಸ ಲಿಸ್ಟ್ ಹೊಸದು
ಬರೀ 47 ಇದೆ
ಅದೇ 47 ಹೆಸರು ಚೇಂಜ್ ಇದೆ
ಸ್ವಲ್ಪ ಚೇಂಜ್ ಆಗಿದೆ ಮತ್ತೆ ಸಬೈಸ್ ನೇಮ್ ಇಸ್ ನಾಟ್ ದೇರ್ The perusal of the list of panel advocates of the DDA indicates that Shri Ravi G. Shabai is no longer on the said panel. Hence, Shri Murugesh V. Charati is directed to accept notice for respondent, counsel for the petitioner to serve copy of the petition along with annexures on Shri Charati. Objections, if any, to be filed on or before 8/7, released on 12/7. Charity, you are appearing. Shri Murugesh Charity has entered appearance for respondent number 1 and 2. Delete C.R. Gopal Swami, C. Ramakrishna. Main direction is early. How date? 19/1/21. Last application I don't know. More advocate change ಆಗಿದ್ದಾರೆ ಅವರ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ. Shri Murugesh Charity seeks fund is granted 2 weeks time to comply with the directions dated 19/1/2021 issued by this court. Released on 4/7. 4/5/7. There is already a direction, you have to comply. You have filed your objections? Fine. When did you file your objection? Not yet. The only wakalat is there. Alibya. The second respondent, you are appearing for respondent number 1. Yes.
Is it 54, Malad?
Yes, Mr. Puttegowda, 54.
54 nalli BBMP party ಇದೆ, but there is no relief, Malad.
ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ ಅಂತ ಇದ್ದಾರೆ ಪೆಟಿಷನರ್, ಏನಾದ್ರು ಆಗ್ತಾ ಇದೆಯಾ?
Against R3, it has to be dismissed.
You are settling amongst you. Who is settling?
The petitioner responded to the TDR, the certificate was issued in favor of the petitioner. By issuing, there is a mistake on the authority. That only the name of Parapata was reflected in the.
Learned counsel for the petitioner submit that there are some settlement talks going on with respondent number 2. Yes, dina beku. 4 weeks alla illa, 4 days. 2018 matter ಇಷ್ಟು ದಿನ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಆಗಲ್ಲ. Relist on 12/7/2022, it is made clear that if no settlement is reported on that case, the matter will be taken up on merits.
Obliged.
Counsel for the petitioner seeks for a passover. Since it's already 4:30, there's no point in passing over the matter. Relist on objections. Akidra, Mr. Jay? Relist on 12/7. Who is appearing for responding? Sachin, you are appearing? 59, you are appearing. Shubhya Sachin has entered appearance for respondent number 2. Delete Narendra Gowda. Petitioner ಬರ್ತಾ ಇದ್ದಾರಾ? Objections ಹಾಕಿದ್ದಾರಾ? CBS Sachin seeks for and is granted 2 weeks time to file a statement of objection. To be filed on or before 8/7, relist on 12/7. But mail and none appears for the petitioner. Sixty-two,
I appeal
for respondent number 5.
I have filed my statement of objection.
File ಮಾಡಬೇಕಾ?
ಮಾಡಿದೀವಿ ಆಗಲೇ ನಾನು ಮಾಡಿದ್ದೀನಿ.
5 ಫೈಲ್ ಆಗಿದೆ. 6 ಇದೆ.
16th March 2020, I have filed my statement of objection.
None appears for the petitioner. Objections of the respondent, if any, to be filed on or before 8/7, relist on 12/7. ಬರ್ತಾ ಇದ್ದಾರೆ petitioner. Interim order is extended till next day. Majority.
Appear for the petitioner.
Ramakrishna. None appears for the respondent. If none were to appear for the respondent on the counsel for the petitioner is present and ready to address his arguments. None appears for the respondent.
Objections ಹಾಕಿದ್ದಾರೆ. ಹಾಕಿದ್ದಾರೆ.
If none were to represent the respondent on the next date of hearing, the matter would be taken up for consideration in their absence. We list on 4/7.
Interim order may be continued.
Interim order earlier granted is extended till next day.
Obliged.
I represent the petitioners, Miller. I have prepared a representation to consider by the VDA to issue NOC for the land which has not been notified belonging to the petitioner. The VDA is neither issuing the NOC nor allowing me to develop my property, which I have sought.
As per
next representation given by
he is the second petitioner. M. Ganga Nagesh is the second petitioner.
Yes, ma'am. Both are brothers. They have jointly purchased the property.
Synopsis ಅಲ್ಲ ನೀವು ಹೇಳ್ತಾ ಇರೋದು ನಾಟ್ ಕನೆಕ್ಟೆಡ್ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಪೆಟಿಷನರ್ ಮುಗೀತು ಅಲ್ಲಿಗೆ. ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಏನಂತ ಪ್ರಾಬ್ಲಮ್? Anything that you receive, you have to pass an order.
We cannot issue a NOC because
ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಒಂದು ಆರ್ಡರ್ ಬರೀರಿ, ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿ ಬರ್ತಾರೆ, ಆಮೇಲೆ ಅದು ಗ್ರೌಂಡ್ಸ್. Mr. Basraj, the representation is submitted in 2019. You don't pass any orders. The petitioner cannot do anything.
there is no provision for issuing NOC.
If acquisition agilla andre, you have to give a NOC saying that you are not acquired. Why is it?
The identification of land is very difficult.
Survey number ಇದೆಯಲ್ಲಪ್ಪ ಮತ್ತೆ
Generally, once a year, ಅವ್ರಿಗೆ ಒಂದು NOC ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ ಕನ್ಸರ್ಟ್ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿ. So ಹಾಗಾಗಿ
ಎಲ್ಲಿ ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಅದು ಇದ್ರೆ
ಅವಾರ್ಡು ಆಗಿಲ್ಲ, ಕಾಂಪೆನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ. ನೋಟಿಫೈಡ್ ದೇ ಆರ್ ನಾಟ್ ಅಕ್ವೈರ್ಡ್.
now start consent award passed by your office for land acquired by you. I request your office to please.
Yes, Mr. Naidu, what is this? Page 43.
Milord.
43 ಬನ್ನಿ.
In page, Milord.
Page 40, in page 43. Your representation.
Yes, Milord.
Second unnumbered para, line 4 or 5.
Yes, Milord. It is submitted that 30 guntas of land is in our occupation. An extent of 12 guntas of land belonging to Ventramanappa, land of Anjanappa and Muralidhara have not been notified by your office, but the owners are not allowed to develop the properties. I have preferred an RTI on 15/12/2018 seeking particulars, but for which on 5/1/2019 an untenable reply was caused, but the proper details have not been furnished by your office. I have sought for the consent award passed by your office for the lands acquired by you. I request your office be pleased to furnish the consent award, but my name is not there in the consent award. That's what I have sought for. They say that in their objection, the consent award has been passed. My name is not there. My vendor's name is not there.
Your application has already been rejected.
No, it has not been considered. No, they said consent award has been passed. Then I have asked for the particulars from them. Even I have filed an RTI application. And for having given the compensation either to me or to my landlady, nothing is forthcoming. Compensation has not been passed. Though there is a somebody else has been given for my property, no consent award was passed. Nothing was given to me. That's what I am requesting them. When they have not acquired, they should allow me to at least enjoy my property.
ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಓರಲಿ ನೀವು ಹೇಳಿದಿರ, ನಾವು ಅಕ್ವೈರ್ ಮಾಡಿದೀವಿ, ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಆಗಿದೆ ಅಂತ. ಅವ್ರು ಕೇಳ್ತಾ NOC ಆದ್ರೂ ಕೊಡಿ, ಇಲ್ಲ ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ತೋರಿಸಿ ಅಂತ ಇದಾರೆ ಅಷ್ಟೇ. Pass an order on it. An order ಮಾಡಿ, Mr. Basraj. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that by representation dated 22/1/2019 and Annexure D, the petitioner has sought for issuance of a no objection certificate or an endorsement that the land of the petitioner has not been acquired. Land of the petitioner in survey number 45/8A of Gollalli village, Uttaldi Obli, Bangalore South Taluk, measuring 30 guntas, has not been acquired. The Sri Naidu Learned Counsel for the petitioner submitted that despite the representation having been submitted way back in the year 2019, no orders have been passed. In view thereof, I pass the following order. The respondent is directed to consider the representation dated 22/1/2019 at Annexure G and pass necessary orders thereon within a period of 6 weeks from date of receipt of a copy of this order.
Right. My lord, serial number 81, my lord. And IO has to
66 ಅಲ್ಲಿ ಇದೀವಿ, 81 ಬಂದಾಗ ನೋಡೋಣ. none appears for the petitioner. The perusal of the list indicates that Sri A.D. Vijaya is no longer on the panel of the BBA. And Sri Lakshmi Narayan and Egde, another standing counsel, is directed to accept notice for the respondent. Registry is directed to delete the name of Sri A.D. Vijaya and print the name of Sri Anshu as that appearing for respondent. Counsel for the petitioner is directed to furnish a copy of the petition along with annexures. Objections if any by 8, relist on 12. ಅಲ್ಲಿ ಹೋಗಿ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕಾಯ್ತು. Sri A. Sampath Learned Counsel for the petition 6 and is granted 2 weeks time, released on 12/7. Yes. Counsel for the petitioner submit that he is unable to get through the petitioner. He seeks for a week's time, 2 weeks time to try and get through to the petitioner. Released on 12/7. Released on 12/7. If no arguments are advanced on that date, the petition will be liable to be dismissed for non-prosecution. Interim order earlier granted is extended to next day. File your objections, madam. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Released on 12/7. Who appears for the respondents? Objections ಹಾಕಿದಾರಾ? Though the counsel for the petitioner is present and ready to address his arguments, none appears for the respondents. If none were to appear for the respondents on the next date of hearing, the matter will be taken up for consideration in their absence. Released on 5/7. Yes. Yes. Just one minute. Okay. Okay. Yes.
That for all those pieces which completely built up on 16th of May 2012, a decision has been taken that they allot them back by collecting betterment charges. Allot the issue was very simple. But I have been made an exorbitant amount of 84,10,500 towards the amount towards the site that I was only prior to the number. My neighboring adjacent sites have been charged 110%. But what has happened is, it's not a question of allotment. I was the owner prior to notification, but because the entire area is built up, they collected betterment charges from me at the rate of 1,500 per square feet. But for others, it's collected only at 159 per square feet. Not I have made several representations. They will not consider it. I find everything for the file representation because I am right to. Seeking for the minus number. Not yet anything page 905 number. I find everything number 15960 from 2017. Seeking for a direction. That the representation stated 2016 to 2016 and 25 and 2016 be considered, and the excess amount of 75,14,900 illegally collected from the refunded number.
Sure. What happened after this?
This repetition of that. Can you take to page 109?
Yes, we have read it. What happened after that?
After that, this was granted and you are asked to consider my representation.
You filed a contempt also.
I want contempt. Contempt will go ahead and they file a problem and do an endorsement to the next year's page 116.
116.
116.
What do they say?
They say we cannot give you money because it was financial loss to begin.
Really?
That is at page 117. The finding, third last thing. Why this is the reason given? I take a specific condition that there are not to be profits. That is one of my grounds for that. That it is not a profit making body. Let's look at what money is making on that. It is not in dispute. Previous order of this also very clearly finds that it is absolutely clear that I have been treated unfairly and a clear violation of Article 14 alert. And can you give the observations alert?
How much have you collected from others? How much have you collected from others? What have you produced? We'll consider it another day. You will have to show us what you have collected from others with the documents. You can't have two different charges. And the reason given that it will cause you financial loss is not a reason at all. Even if BD has to be wound up, you will have to pay the money.
What I have done is I have collected those documents as well. To show that I have collected at 7 lakhs.
Then produce it.
This is a repetition.
It's in the report.
If they have filed a repetition without seeking to reduce the amount of towards then what happened the batch of repetitions that the farmer code has decided within so and so date you have to give explanation. Within so that date the petitioner has not given the representation.
If you have collected,
we have passed the end of passed the resolution in page number 6 of my statement.
You cannot charge two different amounts. As simple as that. There is no other thing. If you have collected the same amount for others, no problem. If you have collected differentially at the same time, then you have a problem. Show us what it is. When counsel for the respondent seeks for and is granted a week's time, we list on 5-7. 70. 78. Objections ಹಾಕಿದ್ದೀರಾ 78. We list on 5-7. 79. Objections ಹಾಕಿದ್ದೀರಾ 79. 2 weeks time is granted to the respondent to file statement of objection. Objection is opened by 8-7. We list on 12-7. It is made clear that no further adjournment to be granted. Ye Loknath. The figure of the panelist indicates that Sri Loknath is no longer on the panel. Hence, the Lakshmi Narayan and Egade is directed to accept notice. Counsel for the petitioner to serve. 4 weeks time is granted to file statement of objection. Objections, if any, to be filed on or before 15/7, relist on 19/7.
81. I appear for petitioner, my lord. And IO may be extended, my lord.
Shri Murugesh Sharati has entered appearance. Delete Ramakrishna. 3 weeks time is granted to file statement of objection. Objections, if any, by 15/7, relist on 19/7. File ಮಾಡಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ಕೃಷ್ಣ? ಅಲ್ಲ, ಮೆರಿಟ್ಸ್ ಆಮೇಲೆ ನೋಡೋಣ. ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಡೇಟ್ ಕೂಡ ಕಷ್ಟ. 82 ರಿಲೀಸ್ ಆನ್ 5/7. ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಮಿಸ್ಟರ್? 83 petitioner is before this court seeking for the following relief. The coordinate bench of this court and so as passed the following order. And that passed the following order. Yes.
84/85.
File ಮಾಡಿದ್ದೀರಾ? 85 released on 5/7.
87.
Your 5. Shri Gautam Des Ullal has entered appearance. Delete Sri Ramakrishna. Released on 5/7. 81 ಅಲ್ಲಿ ಇಂಟು ನೋಡ.
For the respondent, madam.
Yes. Have you filed your objections, madam?
No, my lord, we haven't filed.
2 weeks, 3 weeks time is granted to respond file objections. Objections if any by 15/7, released on 19/7. One 1552 of 2021. So idral objections ಹಾಕಿದ್ದೀರಾ? ಬೇಡ, ಕನೆಕ್ಟ್ ಮಾಡೋದು ಸಾಕಾ? Counsel for respondent submit that above matter is connected to 1552 of 2022-21. Registry direct connect and released on 5/7. (92)
I appear for respondent, your lordship.
Have you filed your objection, Mr. Kiran?
No, your lordship. 4 weeks time.
3 weeks time is granted to the respondent to file the respondents to file the statement of objection. Objections if any by 15/7, released on 19/7.
Much obliged.
ಏನಮ್ಮ? Released on 28/6 at 2:30 p.m. (95) Shri K. Krishna, Learning Counsel submit that statement of objection will be filed during the course of the day tomorrow after serving a copy on the counsel for the petition. Released on 5/7. ಹೌದಾ? Released on 5/7 at 2:30 p.m. Right under 2:30 ಬಂದ್ಬಿಡ್ಬೇಕು. 97. ಎಲ್ಲಿ ಯಾರು ಅಪಿಯರೆನ್ಸ್ ಹಾಕಿಲ್ಲ. ಶ್ರೀ ಬಿ ವಚನ್, the counsel is standing counsel is directed to accept notice for respondent number 1 and 2. Counsel for the petitioner to furnish copies. Objections if any by 15/7, released on 19/7. Acceptable? ಹಾಕಿದಾರ? ಅದೆಲ್ಲ ನಾವು ನೋಡಲ್ಲ. Ready, Mr. Charati? ಮತ್ತೆ ಯಾರು ಕಂಟೆಸ್ಟಿಂಗ್ ಯಾರು?
As per the report, that the property.
I will have it on another day.
Area.
Shri Murugeshwar Reddy has entered appearance for respond number 4, delete Keshava Ragniyoti. We list on 5/7 at 2:30 p.m. We list on 5/7. File ಮಾಡಿದಿರಾ? Objection statement is finished. We filed on or before 15/7. We list on 19/7. File ಮಾಡಿ. 5/7 at 2:30 p.m. Land acquisition BDM. 8/7 at 2:30 p.m.
One not one, my lord. Serial number 101.
101 is 19/7, Mr. Ramurthy. Or objections ಹಾಕಿಲ್ಲ ಅಂತ
ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದಾರ?
ಹೌದು.
ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ನೋಡೋಣ.
I have received the copy, my lord.
Court officer. Court officer. Court officer. 62 ಏನಾಗಿದೆ? Sorry? 62.
62/12/7 entry matter extended.
Thank you very much.
ಬೆಳಗ್ಗೆ ಎಲ್ಲ ಗುರುವಾರ ಆದ್ರೆ ನಮ್ಗೆ ಆಲ್ರೆಡಿ ಇರುತ್ತೆ ರಾಶಿ ನಾವು ಮಾಡ್ಬೇಕು ಸೈನ್ ಆಗ್ಬೇಕು ಕರೆಕ್ಟ್ ಮೇಡಮ್ ಶಾರ್ಟ್ ಡೇಟ್ ಇಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ 5 ದಿವಸ ಮುಂಚೆ ನಾವು ಕೇಳುವಾಗ ಜಾಸ್ತಿ ಡೇಟ್ ಮಳೆ ಕೊಡೋರು ಸಾಯ್ರು ಇಲ್ಲ ನಮ್ಮ ಪೇಪರ್ ಏನೇನು 15 ದಿನ ಬೇಕು ಅದಾದ್ಮೇಲೆ 15 ದಿನ ತಗೋಬೇಕು
ಎಲ್ಲ ತಗೊಂಡು ಆರ್ಡರ್ ಆಗಿದೆ.